Board members, is everyone ready to begin?
Yes.
Excellent. All right, let's start
This
meeting on
meeting
time.
is being recorded.
I'd like to call to order the meeting of the Court Reporters Board of California. It's Friday, November 20th, 2020, 9:00 a.m. Pursuant to the provisions of Governor Gavin Newsom's executive order dated March 17th, 2020, a physical meeting location is not being provided. However, we are holding this meeting via teleconference platform. So if Ms. Bruning, you could please conduct the roll call, we can establish a quorum.
Thank you, Ms. Hurt. Ms. O'Neill,
Here.
Ms. Nocella,
Present.
thank you, Ms. Sunkis,
Present.
Ms. Hurt,
Present.
thank you, quorum reached.
Excellent. Thank you. Thank you. So welcome, everyone. We also have in attendance supporting the board, Yvonne Finner, our executive director, our board attorney for this meeting, Anthony Payne, as well as our regulations attorney, Danny Rogers. Paula Bruning will be assisting us. Shelley Jones will be our lead moderator. I believe Tom is a co-moderator, and there are many others. So I want to thank everybody for supporting this meeting this morning. Also would like to thank the public for bearing with us. This is our second telecommuting meeting, as they say. We truly value public involvement and exchange. So while we're here to do the business of the board, we will try our best to hear from every single one of you. And we've provided this platform to make it happen. So until we can meet safely again in person. I have a few meeting reminders for public comment. It's welcome but not required that speakers identify themselves during public comment period. As this is a board meeting to conduct board business, the board is asking members of the public to limit their comments to 2 minutes. A 30-second warning will be issued before we move on to the next speaker. And because this is a teleconference meeting in the DCA WebEx platform, we're unable to truly know how many folks are in the queue to adjust time. So we are going to try to stick to that 2 minutes. And it's believed that because of this platform, there'll be more speakers. And so we definitely want to get everyone's voice heard while also making sure we get to business. One thing I'd like to note, if you've already heard your comment expressed, please don't hesitate to just quickly state that you agree with the prior public commenter, and you can keep it short so we can hear from everyone. So again, thank you, DCA staff and fellow board members for participating on this platform. And I'll just quickly remind board members that to keep your mic on mute when you're not speaking. And I'll call on you by using the raise hand function. And of course, when you're done speaking, if you can lower your hand, that would be great. So we have a full agenda. Let's get straight into it. I'll let folks know we'll take a 15-minute break and then we'll have a 30-minute lunch and then we'll take another break. However, if you feel like you need another break in that time or you'd like to slow the pace of the meeting, please let me know. All right, let's get straight into it. Agenda item number 1 is review and approval of May 21st, 2020 meeting minutes. Copies of the minutes have been distributed. Are there any additions or corrections by the board members? Okay. I do see Miss Board Member O'Neill's hand.
Yes. On page 24, and I'm over there right now.
Okay.
So, there we are. Okay, page 24. And then towards the middle, right after the middle, towards the bottom, the paragraph says Ms. Equivel.
Yes.
Esquivel, sorry. Right, Jennifer. The, question, the opposition, et cetera. On that second line, I I think it was, we may have said it that way. In other words, the RPR is not a core voice requirement. So I think we just need to amend it for clarification.
So the amendment you're suggesting is what that you heard, and maybe Paula, Ms. Bruning, you could speak to the exact translation.
I believe it should indicate CSR instead of RPR.
Oh, okay.
Thank you. Amendment noted.
Thank you. Thanks for the catch, Ms. O'Neill.
I was
Are there-
channeling Elizabeth.
Say that again.
I was channeling Elizabeth.
Oh. Elizabeth will be with us forever, but through one of us, yes. Thank you very much. Did you see anything else, Board Member O'Neill? I think I don't see, no, okay.
I don't think, no, I'm fine.
You're fine, okay. So I don't see any other hands raised. Are there any public comments on this item?
This is the moderator. I've opened the Q&A panel for requests for public comment. If you'd like to make a public comment, please click on the Q&A icon on the screen. Type, I would like to make a comment into the ask field and submit that to all panelists. We will pause for a couple of moments to allow time for submission of requests. Our first request for public comment comes from my screen to cooperate. Goodness. Janet Harris. Janet, I have opened your line. You will have 2 minutes.
Welcome, Ms. Harris.
Is throughout this strategic planning session, the co-facilitator and I would switch places. One of us would be standing, the other would be seated behind a computer. So we are switching places.
Ms. Harris, it
It
appears
looks like she may not have, no, she does have an audio connection. Ms. Harris, can you hear us?
Give you something to do while we save the PowerPoint and have our partner pick it up.
she's definitely unmuted.
Yeah.
I guess.
She said one moment.
hear me
she's- now we can hear you. Thank you.
Okay, thank you so much. I apologize about that. My name is Janet Harris, and I'm the president of AAERT, the American Association of Electronic Recorders and Transcribers. And I am here today to register our association's opposition to the proposal from CalDRA to include court reporter and deposition reporter.
Oh, okay. If I could, Ms. Harris, we will get to that agenda item. This
Okay.
is actually public comments on our meeting minutes.
I'm
So
so
if you have,
I
yeah,
do
no
have a
problem.
comment on that.
Okay, no comment on that. All right. We will take your public comment later in agenda when we get to that item. So thank you for being here at this meeting. It doesn't look like we have any hands raised to comment on the meeting minutes.
No,
So-
and we have no further requests for comment, so I will close the Q&A panel.
Thank you very much. So we have an amendment of CSR instead of RPR. Would someone like to make a motion with that correction?
I would. I would like to make a motion to replace, can't say a liner, but on page 24, replace RPRs, apostrophe S with CSR with apostrophe S.
And you're also, so you're moving to approve the meeting minutes with the
Yes.
amended CSR.
Correct, I'm sorry.
Is there a second?
Second.
Thank you. Any further discussion? Okay, let's, Ms. Bruning, can you call the vote?
Thank you, Ms. Marcella.
Aye.
Thank you, Ms. O'Neill. Thank you, Ms.
Yes.
O'Neill.
Well-
Ms. Sunkeys.
Yes.
Thank you, Ms. Hurt.
Aye.
Thank you. Motion carries.
Thank you. Minutes approved. Agenda item number 2 is a resolution for Carrie Nocella. Ms. Nocella is leaving our board. It's been so great getting to know you and having your voice on this platform. You have extensive knowledge on the legislative process and have been such a key individual and board member on the work that we've been doing over the years. So I'm sad to see you go. We wanted to create a resolution, and I'd like to read it if folks don't mind, just really quickly. Whereas Carrie Nocella has faithfully and devotedly served as a board member of the Court Reporters Board from June 17, 2016 through November 30th, 2020. She served as co-chair of the non-licensee owned firm subcommittee, whereas she testified before the legislature during the regulations of corporations and the impact on professional licensing informational hearing, and she provided direction on reaching the board's strategic plan goals. She strongly advocated for protection of consumers from corporations practicing outside the requirements of the law set forth by the state of California. Whereas throughout her years of service, at all times, Carrie Nocella has given fully of herself and her ideas and acted forthrightly and conscientiously, always with the public interest and welfare in mind. And now therefore be it resolved that the members of the Court Reporters Board express a heartfelt appreciation to Carrie Nocella for the outstanding contribution she made during her years of service on the Court Reporters Board and to the consumers of California. November 20th, 2020. Thank you so much, Carrie. I will now invite other board members or staff to say a few words. And I see Ms. Finner's hand raised. We'll start with you.
Thank you, Madam Chair. I just want to say that board member Nocella works in a with absolutely no spare time. And I'm so very appreciative of every time that she was able to give up her time to the Court Reporters Board. Carrie, your input at the meetings has been really valuable and has helped the board make the best decisions possible for consumer protection. Your engagement in the discussion clearly demonstrates that somehow, possibly between the hours of 3 and 4 in the morning, you were able to read all of the background materials and you always came prepared to learn, discuss, and decide. And I have to say that your viewpoint will be very sorely missed. So I want you to know that I've really enjoyed the opportunity to work with you, and I wish you the very best of luck going forward.
Well said, Ms. Finner. Ms. Board Member Sunkeys.
Carrie, I have not been able to work with you very long, being new to this board, but I was bummed when I heard that you were leaving so soon to my coming on the board. I wish I would have been able to work with you longer, and I wish you the best. Thanks.
Thank you. Board Member O'Neill.
And in addition, I always appreciated your input on items because for me, it would always add clarity to the issues and on whatever topic we were talking about. And I especially appreciated your ability to hone in on what the issues actually were. And you would make me think of, about different aspects that, had not jumped out at me before. But I think overall, on behalf of the consumers of California, I want to thank you for your service. You will be missed.
Absolutely. When I think of Ms. Nocella, I always think of sunshine. Like she's always ready to go. She's in the board meeting. She's ready to go. Always positive. Are there any public comments?
This is the moderator. I have opened the Q&A panel. If any member of the public would like to make a comment, please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" in the ask field and submit that to all panelists. We have a request from Mike Hensley.
Okay, welcome, Mr.
Mike,
Hensley.
your line is open. You will have 2 minutes.
Good morning. This is Mike Hensley, president of CCRA, and on behalf of the Association of Stenographic Members, I would like to thank Board Member Nocella for her service, and we wish you all the best in your future endeavors. Thank you.
Thank you, Mr. Hensley. All right, I don't believe I see any other hands up. So, all right, I give the floor to Ms. Nocella. Are there anything, would you like to say anything?
Yeah, no, thank you so much. I think this is all so bittersweet. And really my decision to not pursue a second term is really rooted in the chaos that I think my life is, both with work and with home. I have a 14-year-old freshman in high school, so that's a very interesting thing right now. But it's just been very chaotic, like I said. So I want to say thank you to the board and to the staff and Yvonne and Paula and Connie and everyone. They have just been outstanding. I mean, when I think of true excellence in a board and true excellence in a staff, I hands down put core reporters at the top of the list. It was incredibly scary, I think, for me to join a board on a field that I only knew about because I'm an attorney and I've been in the courtroom. But that is just skims the surface, right? That is like icing on cupcake that I think the court reporters field, I have the utmost respect for the industry. I've learned so much. I'm regularly humbled and educated by everybody on the board. All the board members bring an awesome skill set of expertise, both professionally and personally, to do the work of the people of California and protecting the consumers. I will miss you guys terribly. I'm always around to join a lunch if you're in Ontario, and I'll come down during lunch break and say hi. But I can't thank you guys enough for the humility I think you've all shown me, and I've learned from you all, and also just the expertise. So thank you so much, and it's been an honor.
Thank you, Board Member Nocella. Thank you so much for serving on behalf of the California consumers, and we are going to miss you, but not yet, because now we're going to dig right into agenda item number 3, which is a Department of Consumer Affairs update. Do we have anyone here from DCA?
This is the moderator. I have promoted Ryan Perez to a panelist. He's available.
Excellent. Welcome, Mr. Perez.
Hi, good morning.
I'm sorry, may I interrupt? This is Yvonne. We need to vote to adopt the resolution.
Oh, mercy. Thank you very much. Sorry, Mr. Perez. One moment. I got so caught up in wishing Ms. Nocella well on moving along that I forgot to do so. So would someone like to make a motion to adopt the resolution?
I would make the motion to adopt the resolution.
Excellent. Can we get a second?
I would second the motion.
Thank you. Do we have any public comments?
This is the moderator. I've opened the Q&A panel for submission of requests for public comment, and we are displaying instructions on the screen for your use. Please click on the Q&A icon at the bottom of your screen, type "I would like to make a comment" in the ask field, and submit that to all panelists.
All right, I don't see any hands raised, so let's move on to the vote. Ms. Bruni.
Thank you, Ms. Nocella.
Should I abstain from
No.
Would you like to adopt your resolution?
Sure, I will. Yes.
Thank you, Ms. O'Neill.
Yes.
Thank you, Ms. Sunkeys.
Yes.
Thank you, Ms. Hurt.
Aye.
Thank you. Motion carries.
Thank you. Thank you. Thank you. Thank you, Ms. Finner, for reminding me to do that. Now, as I said, agenda item number 3, Mr. Perez, the floor is yours. Welcome.
All right. Well, good morning, Board Chair Hurt and board members. I am Ryan Perez with the Board and Bureau Relations team at the Department of Consumer Affairs, and thank you very much for allowing me an opportunity to provide an update to the Court Reporters Board. But first, on behalf of Deputy Director Holmes, Director Kirkmeyer, and the entire DCA team, I want to recognize the distinguished service of Board Member Carrie Nocella. DCA appreciates your years of superb service and leadership as a member, and the work that you've done on behalf of California's consumers is invaluable, and DCA wishes you all the best.
Thank you, Ryan.
Of course, I don't really have a soft transition into some of the more mundane updates, but here we go. A top priority for DCA currently is efficient and effective investigations. We understand how important investigation timelines are and have made this a priority. To that end, the DCA executive leadership has decided to hire an individual who's very familiar with the investigative process to work with the executive team and the team at the Division of Investigation to identify ways to increase efficiency, decrease investigative timeframes, and improve the overall quality of the investigations. This individual will be reviewing investigations, statistics, and recommendations from DCA's Organizational Improvement Office, which will allow greater assistance to the Division of Investigation. The overall goal here is to decrease timeframes of investigations while still maintaining the level of quality that the boards and bureaus have come to expect from DFI. DCA will provide updates to the board on these changes as they are made, as well as improvements as a result of this additional review. Even though COVID-19 has changed the way that we do business now and in the future, our work does continue. After a temporary closure in March due to state and local stay-at-home orders to prevent the spread of COVID-19, DCA offices remain open with preventative measures to safeguard the health and safety of our employees and visitors. DCA continues to partner with the Governor's Office and the Business, Consumer Services, and Housing Agency on statewide efforts related to awareness and enforcement of public health measures. The economic impacts of the COVID-19 pandemic and unprecedented wildfire activities are expected to last for several years. The state needs to take immediate action to reduce costs and maximize efficiencies to support all Californians. In April, DCA and all boards and bureaus worked to limit expenditures and hiring to only those necessary to support core functions and emergency response activities. Additionally, this week, DCA learned the department will be required to take a 5% permanent budget reduction no later than the 2021-2022 fiscal year. Each board and bureau will be asked to develop a plan for a permanent 5% reduction, and DCA will be working with board staff immediately to identify a plan that will best fit the board's operational needs. And we would like to thank the board and staff for your continued service despite these challenges. Lastly, I would like to update you on some of the work that Board and Bureau Relations is doing to support the board's executive team, along with board and bureau leaders. Board and Bureau Relations has put on 3 brown bag trainings this fall to provide executive officers the opportunity to learn and discuss best practices on topics such as appointments, managing staff remotely, and providing ADA compliant meeting materials to board members and the public. In partnership with DCA's Solid Training Unit, board member orientation trainings have been held quarterly as remote sessions, and new training for board presidents is in the planning stage. I and the rest of the Board and Bureau Relations team looks forward to the day that we can actually meet in person. But in the meantime, if you have any questions or need anything from DCA, please do not hesitate to reach out to any member of the Board and Bureau Relations team. And again, thank you very much for inviting me to your meeting. And that concludes my presentation. I will turn it over to Board President Hurt. Or Chair, I'm sorry.
Thank you. Thank you, Mr. Perez. We appreciate those comments. Are there any questions from board members for Mr. Perez? Okay, and I guess I'll turn it to public comment, see if there's any public comments on this item.
This is the moderator. We have opened the Q&A panel for submission of requests for public comment. Please click on the Q&A icon at the bottom of your screen. Type "I would like to make a comment" into the ask field and submit that to all panelists. We will pause for a moment to allow time for submission.
Okay. All right. Well, thank you, Mr. Perez. There's definitely challenging times for our state and for this board as well, with the changing industry and tightening our belt, so to speak, so we can meet that 5% budget reduction. So thank you very much for your time, Mr. Perez.
Of course. Thank you.
All right, that was informational. We do not have a board action, so that will take me to agenda item number 4, which is report of the executive officer. Ms. Finner, if you could please give your report.
Thank you, Madam Chair. I would like to start out by welcoming our newest staff member, Sheila DeGrace. She's going to be working half-time as an office technician for the board. She started on November 9th and is really busy learning the ins and outs of what we do here at the Court Reporters Board. And I can let everyone know that the rest of staff is really happy to have her on board. On page 32, you'll see the final numbers for last fiscal year, the 2019-2020 fiscal year. I'm sure that all of you have noticed the different format. This is how the reports are going to look going forward. As you can see, we reported a little over 77,000 at the end of the year. I like to steal a line from one of my very first budget analysts and say that even though our entire budget may not rise to the level of budget dust, it's a really good revision for the board, and I really thank staff for working so hard to keep our expenditures as low as possible. And I'd be happy to answer any questions on last year's ending numbers.
Thank you. So I'll turn it to the board. Are there any questions on this item? Okay, don't see any hands raised. I just have one question. You know, I'm always looking at our costs, and of course, personal services is always where the bulk of our budget goes to. And I kind of draw my attention to the temporary position. Could you speak a little bit about that number? I know we've lowered our taking tests. Obviously, we're not doing that in a big hotel anymore. And I know this is 2019. So could you speak just a little bit to our temporary position and what that number is?
So the board has not received authority from the Department of Finance for Melissa Davis's position. And so she's considered temporary help in the blanket, as they say, until we get approval for her position.
Understood. Thank you. And then I was curious about the special items of expense, the 62,000, that's item number 54. It's under operating expenses and equipment.
I'm sorry. I'm not sure if Marie Reyes is attending. She's our budget analyst. If we could promote her, if she's on.
This is the moderator. What was her name again, Yvonne?
Marie Reyes.
I do. I will promote her. I will unmute her microphone.
Thank you.
Marie, you're a panelist and your microphone is unmuted.
Good morning, everyone. Can you hear me?
Yes. Hello, Ms. Reyes.
Hi, how are you? It's been a while.
Yeah.
The 62,000, actually, that was an adjustment. I have sent the revised one, and my apologies on that portion. There was an adjustment made towards the end, and that 62,000 should not have been a part of it. That's why on the very end of the spreadsheet, when you would look at column G, it did show only $551 with a balance of $551.
Okay.
There are accounting adjustment that's added on or that's made correction towards the end of the year, and that is one of them.
All right.
So the amount for special adjustment should only be $551.
Thank you for clarifying.
You're welcome.
62,000 is a lot in our budget.
Yes, it is. Yes, it is.
I know other boards have bigger budgets, but that's a lot in our budget. So
I understand. The actual amount for the special line item is $551, and that's for digital printing services.
thank you. Okay, I don't see any other hands raised, so then I guess we'll move on. Thank you very much for that
Thank you.
information. Ms. Finner?
Thank you, Chair Hurt. Moving on to page 33, you have the overall fund condition of the board. This is what the fund looks like without any transfer to the transcript reimbursement fund or the TRF. As you can see, that slightly larger reversion helped us end the fiscal year in a position to be able to reopen the TRF in the beginning of November. So page 34 shows what the fund will look like if we transfer $100,000. And then page 35 shows what the fund would look like if we transferred $200,000. Obviously, all of these figures are projections based on the data that we have today. And so staff and board will monitor the fund conditions through our regular reports to the board, so you can see how we're doing with that fund. Our executive analyst, Paula Bruning, is going to update you on how staff prepared to reopen the fund and the activities since it opened.
Excellent, thank you. Ms. Bruning?
Thank you. We worked closely with the staff from the Office of Public Affairs that helped us to revise the application forms and guidelines in hopes of making them more streamlined and clear and avoid deficiencies and rejections based on incomplete applications. Matt Woodchuck was very instrumental in helping us with that, so we appreciate that. He also worked with our sister agency or our friends at the Publication Design and Editing to actually create the forms and give them their overall look. And then, of course, we worked with the Office of Information Services web team to develop a new menu or tab on our website that's dedicated to the Transcript Reimbursement Fund, provide updated information, hopefully make it very clear which part of the Transcript Reimbursement Fund a person would qualify and apply under. As of this date, we have received 28 applications for the pro bono pathway of the Transcript Reimbursement Fund. One of those was withdrawn as incomplete. And then we received 7 applications for the pro per program, and one of those was rejected. So far, the Transcript Reimbursement Fund, since opening on November 2nd, has paid out just under $1,600 and provisionally approved one application for $500. Be willing to answer any questions the board may have.
Thank you, Ms. Bruning. Board members, please raise your hand if you have any questions. Okay, I don't see a raised hand, so let's continue on.
If there are no other questions on the budget, I would like to take a moment of personal privilege to recognize the hard work of our budget analyst, Marie Reyes. Marie has helped the board transition from our legacy accounting systems into the new fiscal system, which is the hugest of undertakings. The amount of work that she has done in setting up spreadsheets to track our revenue and expenses is truly amazing. All of that hard work allows her to answer any question that we pose to her, and it allows our board to make the best decisions in the context of knowing our true financial position. And I have no doubt that she's incredibly busy, and we're certainly not her only board, but she's always been really readily available to me to answer questions and give reports that I've requested. Personally, I'm thrilled that she's soon going to retire. But I have to say that professionally, I'm really devastated to lose such a helping hand. Marie, congratulations on your retirement, and it has been truly a pleasure working with such a competent professional, and your kindness to our board will be very sorely missed. We wish you the best of luck.
Absolutely. Thank you for, thank you.
Oh, thank you. I'll miss you guys too.
Moving on to pages 36 and 37, that's the first quarter enforcement statistics. There aren't any really new trends or anything of significance to point out to the board. I don't know if anyone has any questions.
Any questions, board members? Doesn't sound like there's a trend or anything we need to be concerned about with these numbers. I don't see a hand raised, so you can continue, Ms. Benner.
Okay, so pages 38 through 43 contain the historical exam statistics through the most current results. Clearly, the most significant change that we encountered moving forward is putting the administration of the skills test online. As you will recall, it was May 21st when the board gave staff the direction to administer the July test online. Lucky for us, the contract with the online vendor, RTC or Real-Time Coach, was already in place. So that left staff only a few things to do. And yes, that is definitely sarcasm. I have a huge thanks going out to our licensing analyst, Kim Kale, who was not only tasked with rewriting all of the instructions for the candidates, but she also had to learn the entire RTC system. Well, Kim was busy with that huge chunk of the chore. Paula Bruning took the lead in working with DCA's television specialists to help us figure out how to safely record a bank of tests with 4 speakers who, for obvious reasons, would not be wearing masks. Huge thanks going out to our readers who traveled during the pandemic to assist us with recording. And it's just kind of amazing to me that so many people put so much time into pulling this together in time to have it ready to roll by July. It was truly phenomenal. It really speaks to the dedication of the board and DCA staff, as well as to our readers. So it's inspiring to me personally to be around so many people who care about being excellent. As you can see at the bottom of page 38, the results of the July exam were very close to the results that we got at the March exam, which was the last one administered on site. In fact, the first time pass rate was slightly higher. I think the board can celebrate the fact that licensing successfully continued uninterrupted during a global pandemic. That being said, it was not all smooth sailing. With any new project, everything didn't work exactly as we had envisioned. Some issues came up. Some of the issues that came up were things as simple as we overlooked when we were preparing the videos. We didn't include the speakers' names on the written glossary that was offered during warm-up. The speakers verbally identified themselves, but we never provided the spellings for the candidates. There were a number of issues with proctors, and we made some improvements to the instructions that the proctors received. There were 100 million variations of internet issues. We realized that we set up a practice test for the candidates to test out their equipment and their connectivity, and it was only 2 minutes long. But when it came time to take the actual test, which is 10 and 15 minutes long, that full practice video takes a lot more traction, I guess, from the internet connection. And so we replaced that with a full-length practice test so that the candidates can do a full test on their equipment. All of the issues that we got reports on from the candidates were evaluated on a case-by-case basis. And we made decisions, taking all of the information particular to each candidate's situation. I have to say that what really came out of the whole process is that the candidate who was able to read and follow written instructions had a better chance at success with the online exam. A lot of people, because so much is online now, feel that they can intuitively move through the screens and answer questions. It's not quite that simple. So it is really important to do the practice tests that are provided, do the practice proctor tests that are provided, and follow the written instructions. I would say that one of the things that created the most angst among the candidates was the change in the appeals process. Just as a reminder to the board, when we administer the test on site, we use one test. And so at the end of the grading, we can make it available to the candidates so they can listen to their group, the reading at their group, and they also had access to their test transcripts. The online skills test now is more a mirror image of what we do with the online written tests, in that there is a bank on the written test, there's a bank of written questions, and the test is developed from there. Now we have a bank of video tests for the skills portion, and we open the window for 3 weeks for the testing cycle, and the candidate logs on and gets a random test offered to them. So if the candidate's not successful, they're locked out of that test permanently, and that next testing cycle, they would get a new test. But because we're using a finite bank of tests, there's no way for us to give the transcripts back to the candidates or allow them access to the video or audio afterwards, since those tests will be removed. It's just for security purposes. Recognizing that the appeals process would basically be going away, the board staff on the grading side really stepped up to make sure that no candidate is unfairly failed, and the grading procedure got a little bit more rigorous. So the test is initially graded by the computer, but because we have a 4-voice format and there are unlimited ways, basically acceptable ways of setting up the colloquy, a human grader then rechecks those results. And if the candidate is within 20 points of passing, it's passed on to a second human grader for rechecking. And then at the end of the day, if a candidate is within 10 points of passing, we have a third person that rechecks it and looks at it again. So because that appeal, there is no appeal process, then it's only a pass fail. And we reflected that in the results letter that went out. Again, that's another change that's hard to accept for the candidates, but at the end of the day, it doesn't matter if you've missed by 5, 10, or 20, it's just a pass fail. And I would say that the new testing cycle began on November 16th. It is scheduled to continue through December 7th. We have 87 candidates who have applied for the exam. Of those, 15 are first timers. Of the first timers, 6 have qualified through the schools that are recognized by the CRB. So I'm happy to answer any questions on the test or the testing process by the board or the public.
Thank you very much, Ms. Finner. Board members, are there any questions? I mean, this is definitely a big change for our board, and I want to thank the staff for working through the many details of transitioning to online testing. And change is hard, without a doubt, but it sounds as if we're pivoting well to meet the challenge here. I don't see any hands raised. Ms. Finner, would you like to take public comments and questions now, or would you like to wait till the end of your agenda item?
If anyone has questions on the exam, I think we should talk about it while we're all on the same page.
Okay, sounds great. All right, I'll now turn to public comments, and I do see at least Ms. Batista's hand raised. So
Yes, this is the moderator. I have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon at the bottom of your screen, enter "I would like to make a comment," and send that to all panelists. Our first request for comment is from Heather Batista. Heather, your line is unmuted and you will have 2 minutes.
Thank you. Can you hear me okay?
yes, welcome.
Thank you. I just wanted to say thank you to the board members and Kim Kale for your dedication to the testing process continuing during this pandemic to ensure that the consumers of California would continue to be served by licensed court reporters. Thank you.
Thank you very much for your comment. Do we have any other public comment speakers? I don't see any hands raised.
I do not see any requests for comment or hands either. I will close the Q&A panel.
Thank you very much. Thank you, Ms. Fenner. We can move on unless there are any. I don't see any hands raised by board members, so we can continue on to the next item.
Okay, continuing on, I would just note that the fall edition of the CRB today is up on our website. It will be up Monday. Paula just corrected me, and I have a huge shout out to Paula. She managed to shepherd this entire production despite she was preparing for the board meeting, reopening the TRF, and hoping to train our new office technicians. So again, speaking of people that work between the hours of 3 and 4 in the morning, she's done an amazing job. So I know that the newsletter was sent electronically to board members. If you have questions or comments, we'd love to hear that.
Well, I'll just say a job well done. I mean, Ms. Bruning, superpowers, just being you and getting this out quickly and putting it all together, as well as Ms. Finner. Thank you so much. I think the newsletter is great. Board members, any hands raised on this one that you'd like to speak to? Okay. Well, everything is going well. So I'll pass it back to you, Ms. Finner.
The final item I have is the business modernization. I'm happy to announce that the board is now able to accept online renewals. There are a handful of exceptions, such as if your license has been delinquent for more than a year, or if you have an outstanding balance on the citation of a fine, you're not able to do that. But the full list of exceptions is listed on our website, and it's also in our newsletter. Again, another huge effort by staff, took a lot of staff time by Paula and Kim, and it's another nice thing to check off our list.
Yes, this is music to my ears.
About time, right?
It's taken a long time, but we've made it across the finish line. Thank you all, staff.
We were almost to the finish line when we had to change the vendor. So, but we did it. We're there. And if there are no other questions from the board, that would conclude my report for the board.
Well, thank you. Thank you very much. I do not see any hands raised. Board members, any thoughts, comments? Okay, we did take a public comment directly on the exam update, but now I'd like to turn to the public to see if they have questions or comments on any of the other 4.1 through 4.6 items that they would like to share right now.
This is the moderator. I've opened the Q&A panel for requests for public comment. Again, click on the Q&A icon on your screen, type "I would like to make a comment" into the ask field and submit that to all panelists. We will take a brief pause to allow some moment for submission.
Okay. All right, I don't see any hands raised, so
I will close the panel.
Thank you. Thank you very much. There's not a board action here. Thank you for the update, Ms. Fenner. Agenda item number 5 is public comment for items not on the agenda. Public members are encouraged to provide their name and organization, if any. The board may not discuss or take any action on an item raised during this public comment section, except to decide whether to place the matter on the agenda for a future meeting. That's definitely a possible conversation quickly had. Otherwise, we will just listen attentively, take great notes, and take it back to the board for consideration. So I will now turn to public comments to see if we have anyone who wants to speak on items not on the agenda. Not on the agenda.
This is the moderator. The Q&A panel is open for submission of requests for public comment. We will pause for a few moments to allow time for that.
Okay, I don't see any hands raised. I did
We-
have in my, oh, yes.
We do have one request from Heather Bautista.
Oh, okay, absolutely. Sorry,
Heather, it's okay. Heather, your line is unmuted. You will have 2 minutes.
Thank you. I just wanted to make a request that in the future, if the public comment for items not on the agenda be placed closer to the end of the meeting, because I think that, I don't know, it just makes more sense because there's a lot of on the agenda, a lot of hot topics that people really want to get their opinions out on. And so I think if the public comment for items not on the agenda maybe come after all those listed, that would just be a request of mine for future meetings.
Thank you for your comment. Yeah, I sit on several boards. They have these positioned in different places. I think most of my boards that I sit on are placed at the beginning. So people, if they have something not on the agenda, they can respond and not necessarily have to wait all the way to the end. And you're right, we have a lot of great topics on. So during those items is when public comments should happen. Are there any? Yes.
Seeing no other requests, I'll close the panel.
Excellent, thank you. All right then. So I did have in my notes to take a break at this moment. However, our time would be much further. I just want to turn to board and supporting staff to see if a break is in order for anyone. And I don't see a raised hand. So I'm just going to continue on a little bit. We had envisioned that the time would be further along for that break, but I think we can take on our next item and then a break. So this brings me to agenda item number 6, which is the digital recorders. This is an update to the board on allegations of fraud and unlicensed activity. And I'll turn to Ms. Finner to possibly give a staff presentation or introduction to this item.
I have just a very brief reminder for the board how this came before us. We had a request for the board to place the topic of digital recorders on the meeting agenda. I would just say that, as we noted previously, the board does not license digital recorders, and we don't have any jurisdiction over their practice. The practice of shorthand reporting is defined for us in Business and Profession Code Section 8017 as making, by means of written symbols or abbreviations in shorthand or machine shorthand, of a verbatim record of any oral proceeding, deposition, court-ordered hearing, or arbitration, or proceeding before any grand jury, referee, court commissioner, and the accurate transcription thereof. So by this definition, the digital recorders are not practicing shorthand recording without a license. I would also point out to the board that attorneys have a statutory ability to stipulate in writing to an alternate form of recording a deposition. Another reminder to the board is that we perform the mandate given to us by the legislature, but within the strict confines of the statutes that have been enacted with regard to shorthand recording, and the board cannot exceed its authority. With any complaint that we receive, the first thing that we have to establish is that we have jurisdiction to take action, and then we look to see what statute is violated. Is it something that we have authority with? It's board staff's position that this is a consumer awareness issue, and it's best addressed via education of attorneys and litigants as far as the advantages of hiring a licensed reporter. I don't know if there's anyone from the group that asked to put it on that's in attendance and would like to speak to this, but that's the background from staff, Madam Chair.
Okay, thank you. And I'll just add before we turn to a representative of that group that this request has been made several times. out in the public. There's been a lot of misinformation, and so we thought it was important to put this out in a public forum so that we can clarify and let folks know legally what it is we can and can't do, and the confines in which we work, the legislative mandate. Let me see, before I turn to a representative, if there is any, let's see, I don't see any hands raised for questions from the board of staff. Okay. All right. So is there a representative of the Protect Your Record Project who'd like to speak? Please raise your hand. Let me turn and see if I can. We'll give you about 10 minutes, not the usual 2 minutes, because it is a agenda item that you've requested to put on, and we would like to give you time to express yourself. So
I see two individuals.
Okay, so we need just one representative at this time for that 10 minutes, and then an additional speaker can be at public comments for 2. So who would like to take this 10 minutes to represent the Protect Your Record Project?
It looks like Kelly Shaneline or Kimberly Dierso. I will unmute both of them and let them tell us which one's going to do it.
Yeah, I think that's the plan.
Okay, there we go. Kimberly and Kelly, you're both unmuted at this time.
Good morning, board. I am actually speaking for Charlotte Matthias, who is in emergency surgery for a gallbladder.
Oh, no.
And so I will be reading her statement on behalf of herself and Protect Your Record. I just couldn't sign in as her because she's in the hospital.
No problem. And then Ms. Shaneline, you have your hand raised. Can you wait till public comments?
Yes, my comment is about 2 minutes and 30 seconds, and I'm hoping you guys would oblige, since I don't believe that Kimberly's will be a full 10 minutes.
Okay.
No, mine will be much less.
Okay, excellent. Okay, thank you. Consensus building here. All right. So thank you for muting Ms. Shaneline. We'll get back to you here in a moment. And Ms. Dorso, if you could please speak.
Thank you, Chair Hurt. My name is Charlotte Matthias, CSR 9792 RPR. I would like to thank Kimberly Dierso for reading my statement to the board. The CRB states under Agenda Item 6, Summary, pursuant to Code of Civil Procedure, CCP Section 2016.030, parties may modify the procedures for any permitted method of discovery by written stipulation, quote unquote. However, the activity brought to this board does not fall under this category. Attorneys, consumers, have not entered into a written agreement to use a notary to digitally record their deposition. These attorneys believe that they have a CSR as they have requested a court reporter. A notary calling themselves a court reporter is deceptive. A notary is not a court reporter. Alarmingly, at the Legal Secretaries Association meeting I attended this year, a well-known unauthorized California court reporting firm suggested to secretaries present that they should update notices to request a notary public present instead of a certified court reporter. That absolutely does not meet the standard of a written stipulation, as opposing counsel is unaware that the notary digitally recording the testimony is not a licensed court reporter. Opposing counsel often discovers this fraud when readback is requested and the notary is unable to perform what attorneys expect from a certified court reporter. Transcripts, excuse me, from a notary do not say the notary public. It says the court reporter, thus deceiving the attorney, the consumer, again, into believing they had a certified shorthand reporter, also known as a court reporter, and not to question whether the transcript they paid for is from such certified court reporter. I see that the recommended board action is to reach out to the state bar to educate attorneys. Has this been done? The CRB published a 5 reasons why you choose a licensed court reporter handout. Has that been sent to the state bar? That handout begs the question, if you should choose a licensed court reporter, does that mean there is such a thing as an unlicensed court reporter? The Department of Consumer Affairs states that they are a regulator. DCA works with professions throughout California to guard licensees against unfair competition and to protect consumers from unlicensed practitioners, quote unquote. The CRB states on its own website that they will investigate fraud and other crimes. However, they also state the board does not have jurisdiction over electronic recording and video operators. These types of complaints will be referred to the appropriate agency if possible, and the complainant will be notified. Has that been done yet? I am requesting the CRB do its job and immediately forward this deceptive activity to the appropriate agency to protect the consumers of California. Thank you, Charlotte Mathias, CSR 9792 RPR. Thank you.
Thank you for that presentation. Okay, I will now bring it back before the board to see if there are any questions of Ms. Dorso. Let's see if there are any. No, I don't see any hand raised. Any comments or thoughts about this item from the board? I will just say with regards to why you should choose a licensed court reporter, that is actually on our agenda today, and we went through the process of creating this, and we will hopefully approve it today. So it's not out and sent to the bar just yet. Okay, I don't see any hands raised by the board, nor do I see any comments. So I will now take it to public comments. I do see hands raised there. If we could begin that section.
This is the moderator. I have opened the Q&A panel for requests for public comments. If you click on the Q&A icon at the bottom of your screen, type "I would like to make a comment" into the Ask field, and you can submit that to all panelists. Our first request comes from Kelly Shaneline. Kelly, your line is unmuted, and you will have your 2+ minutes.
Thank you so much. Good morning, members of the board. My name is Kelly Shaneline, CSR number 13476. I am speaking today on behalf of myself and the Protect Your Record Project. Since the last board meeting held on May 21st, 2020, where Protect Your Record Project and many other members of the court reporting community voiced their concerns regarding the rampant use of digital recording, mostly seen from out-of-state, unauthorized foreign corporations, there has been an escalation in how these firms are operating and are proving to be a risk and harming consumers as their unethical practices continue to go unchecked. With this escalation of unethical behavior, Protect Your Record Project is appalled to have now been made aware of fraud on the court. A foreign corporation doing business in California has now taken an unauthorized audio recording from a court proceeding where a freelance reporter was deemed to be the official record, had it typed up by a transcriber out of state, who then used the initials CSR after her name, leading everyone to believe she was a California certified shorthand reporter. The attorneys then filed the transcript with the court as if it was the certified transcript from the official reporter. They had no idea they were filing an uncertified transcription of an audio recording and representing to the court that it was a certified transcript. This is just one alarming instance of consumer harm that is happening. We bring this situation up because we believe that the silence from this board on these critical issues is actually a green light to these corporations to do whatever they please, as they know this very board, who should be governing the court reporting profession, will not touch them. If the Court Reporters Board of California does not believe they have jurisdiction over the court reporting profession, as the board, it is up to you to protect the consumers and get help from the legislature or fix the regulations that need to be fixed so consumers are protected and the integrity of the record can be maintained. The board has known about electronic recording for over 30 years. At the board's planning session held on February 9th and 10th in 1990, the board determined that it should examine the use of electronic recording and had a variety of options it was looking at. It seems that ignoring the issue was the outcome. I encourage the CRB to revisit this and protect consumers who utilize court reporting services. To just keep stating it is not your jurisdiction is actually causing harm. We have continued to ask who has jurisdiction over this, and we still have not gotten an answer. Thank you for allowing me the opportunity to speak today. Thank you.
Our next request for comment comes from Kim Kuziora. Sorry if I mispronounced your last name. Your line is unmuted and you will have 2 minutes.
Hi, I'm Kim Kuziora, CSR 8509. My statement is related to the documents I provided to the CRB that are in the agenda packet. The California Secretary of State confirmed in an email that if notaries public perform depositions, they may not record and transcribe the deposition unless they are California licensed CSR. Notaries can take the deposition by hand in longhand or by typing in longhand. I filed multiple complaints with the Secretary of State's office related to notaries public calling themselves court reporters and digital reporting depositions. One of my notary complaints included the deposition notice and transcript that I provided to the board. This is an example of the fraud and deceptiveness that is happening. The depo notice says the depo will be before a certified court reporter, and a notary public was sent to digitally record the depo. There was no written stipulation per CCP 2016.030 to allow this depo to be taken by a digital recorder, but the unlicensed court reporting agency sent the digital recorder anyway. The notary stated on the record, all parties agreed to the digital recording, but one of the attorneys stated they did not agree to stipulate. I personally spoke to this attorney. They were horrified that this bait and switch was allowed to happen by the CRB. They were backed into a corner to have to allow the deposition to go forward because of discovery deadlines. Attorneys have a reasonable expectation that when a depo notice requests a certified court reporter and someone calls themselves a court reporter, that person is a licensed CSR. This transcript was certified by the notary and transcriptionist. For CCP 2025.340M, this transcript would not be admissible evidence because it is not a stenographic transcript. As pointed out on the March 2020 attorney email that I submitted, this transcript would be useless in an insurance fraud situation where a district attorney would need to use a transcript for criminal prosecution. Bill Downs, the notary public section manager at the Secretary of State, told me that the CRB should be handling my complaint. He asked for a contact person at the board. Mr. Downs instructed me to also send my complaint to the district attorney's office. The LADA sent me the letter that I submitted saying that my complaint raises an issue of possible deceptive or unlawful business practices by a notary public, and the investigation for this is usually handled by the CRB. I respectfully request that when the CRB receives digital recorder complaints, they adhere to their duties for Business and Profession Code 129B. If the complaint is not within the jurisdiction of the board transmit the complaint to the appropriate agency. Thank you.
Our next comment comes from Mike Hensley. Mike, your line is unmuted. You will have 2 minutes.
Good morning, Madam Chair, members of the Board of Directors. This is Mike Hensley, President of CCRA, and I speak to you on behalf of our entire membership, both stenographic professionals and those who are pursuing the practice of stenographic profession. I would like to say that CCRA stands in support of the comments made by members of Protect Your Record Project and those with similar opinions. I would also like to remind the board that for many years, California and its practice of court reporting has been a front runner in terms of upholding the gold standard expectation and the highest levels of competency in our profession. At this time, there are other states, and there is even a national association that recognizes the danger of digital reporting and has acted in accordance by either directly outlawing the practice of digital recording or by providing strong documentary evidence to counteract the infiltration of this practice into our profession. In order for us to remain a viable front runner and a shining example of the high standard of our profession, I would encourage the board to thoughtfully consider the comments that have been presented here today and to take serious, decisive action to promote and to promulgate the viability of stenographic reporting as it relates to certified shorthand reporters, otherwise known in common parlance as court reporters. Thank you.
Thank you for those two speakers.
At this point, we have no further requests for comment. I will close the panel.
I do see Mr. Orso's hand raised. Is that
I believe it's still up from before. We can check in though.
okay?
That's correct. I don't have anything further. Thank you very much.
Okay, great. Thank you very much. Just wanted to make sure, didn't want to leave anybody out. All right. So we've received public comments. I'm going to bring it back to the board to see if there are any additional questions, comments, a discussion. The recommended board action is from the staff is to reach out, as was said earlier, to the state bar and educate attorneys on the importance of requesting a certified shorthand reporter. As you all know, the board knows that our role is to protect consumers, and there needs to be not only consumer harm, but also jurisdiction. And today it sounds as if we don't have that per the laws and rules we currently have, and a real step forward to the legislature to expand that capability is what's in order. So again, I'll bring it here to hear board comments. And I don't see a raised hand. Oh, thank you. Board Member Sunkeys.
I would move that we direct staff to reach out to the state bar to educate attorneys on the importance of requesting a shorthand reporter.
Thank you. Can I get a second?
Second.
All right. So now we will take public comment.
This is the moderator. I have opened the Q&A panel for requests for public comment. Please click on the Q&A icon on your screen, type "I would like to make a comment" into the ask field, and send that to all panelists. We will pause for a moment to process requests for submission. And again, for those of you and our public attendees, if your hand is currently raised, if you could please lower your hand and utilize that Q&A feature. Thank you.
Okay, on my end, I see Ms. Shaneline still has her hand raised. Would she like to make a comment on this motion?
We can check, and I believe it was still raised from earlier.
Yes, correct. Still raised from earlier. I just don't see on my screen where the little hand is, but I'll hunt for it. Turn
Okay,
it on.
thanks.
Thank you very much.
We do have a
Okay.
request for comment from Kimberly DiUrso. Kimberly, your line is unmuted. You will have 2 minutes.
Thank you, Madam Chair and Board. I appreciate you stating that you will reach out to the state bar. I would also request on behalf of the Protect Your Record Project that you publish a similar statement, educational statement on your website regarding the importance of hiring a certified shorthand reporter, AKA licensed court reporter. Thank you so much.
Thank you for your comments. And I believe we absolutely will reach out to the state bar, and we'll see what we can do as it relates to on the website.
We also have a request for comment from Mike Hensley.
Okay.
Mike, your line is unmuted. You will have 2 minutes.
Thank you. It's been stated by Madam Chair and other members of the board that they feel that they do not have jurisdiction over the practice of digital recording. However, I would remind the board to review the documentation that was provided in relation to this commentary, stating that according to BPNC section 8018, there is actually an outline for oversight of those who attempt to perform the practice of using words or symbols or tending to indicate that he or she is certified under this chapter. So though there may be an understanding according to 8016 that there is not jurisdiction, 8018 would otherwise say that there is jurisdiction for oversight on this matter. CCRA would encourage the board to review the code in this light so that they can determine suitable action thereto. Thank you.
Thank you. Do we have any other public comments on this motion?
I see no further requests.
Okay, I'll bring it back to the board. There's a motion and a second. Is there any further discussion by the board members so we can move to, okay, I see Miss O'Neill's hand raised, or Board Member O'Neill.
Thank you. I'm just going through this, and well, there's much to be discussed, you know, about everything that all the people brought up. For some reason, while I was going through my board book and I was looking all of this, and I was looking at the code sections and thinking about it, I remembered out of the blue back in the 1980s, and I was a child prodigy then, so you're not, you know, I'm not that old, but that was around 83 was the time when reporters could not report depositions any longer without a CSR license. I was not involved on the state or level or anything like that at that time, but at least in my area, in Southern California, you know, the Inland Empire area, the desert area, et cetera, somebody must have gotten to those attorneys, because what we all noticed is that when, you know, each of us would go to a deposition, one of the attorneys, he didn't, you know, it wasn't always a taping attorney, but we were being asked to show our license every time that, before we started up the deposition. And eventually that died out because they were getting evidence of licenses when they were asking that question. But, you know, within the educating of attorneys, I would recommend that also be put in there, asked to see the license, you know, the CSR license. And just, just something to keep in mind. And I will go ahead and, that's all for now.
Question in a second. So that was your additional discussion. Thank you for that additional comment. And
Yeah.
I see Director Sunkeys, her board member Sunkeys hand open or up. Would you like to say anything else further?
Oh, no.
Okay, thank you, Board Member O'Neill. You can mute yourself, and I'll turn to Board Member Sunkeys. Your hand is raised. Would you like to speak?
That is raised because I forgot to put it back down.
Okay, all right, perfect. And I just want to comment that it is already on our website, so you can find that there. Thank you, Ms. Finner, for updating me on that. So we have a motion, a second. We took public comment. We just had additional discussion. And so now I will turn to a board vote.
Thank you, Ms. Nocella.
Yes.
Thank you, Ms. O'Neill.
Yes.
Thank you, Ms. Sunkeys.
Yes.
Thank you, Ms. Hurt.
Aye.
Aye, thank you. The motion
Aye.
carries.
Yes. Great, thank you. So we have a path forward on that, and it's been in a public forum. So I appreciate that discussion and moment on that item. So that takes me then, how about we now take a 15-minute break? I think maybe we should do that. If everybody's in agreement, or let's see. Yeah, I think this is a perfect time so we can give everybody who's involved with this 15 minutes. Thank you. All right, it's 10:35. I believe I see almost all of our board members. Just we'll wait a minute or so for Board Member O'Neill. There we are.
Yes, I'm here.
Welcome. Good, good, good. Okay, I think I see everybody. Recess. We're back from our recess here, and we're going to move on to agenda item number 7, which is the license certificate reciprocity. We talked about this at our last meeting, and I believe at that meeting we appointed Board Member O'Neill and Board Member Sunkeys to move this effort forward. This is an informational, so who would like to start off this item?
Madam Chair, I'd like to report back on our meeting that we held with our task force on June 26th this year. And actually, on behalf of Ms. O'Neill and myself, we were co-chairs for this task force. We are co-chairs. I'd like to, on behalf of Tony and myself, I'd like to thank Stephanie Leslie and Heather Batista, who are both members of this task force, as well as the representatives that participated on behalf of Texas. There's a long list. I won't list everybody that was there, but we had members from their judicial branch, as well as members from TCRA and TXDRA, their state associations there. And the reason for this meeting was because Texas had proposed a reciprocity licensing between our two states. And Texas felt like California's test was substantially equal to theirs, and this would be a good thing. This would be a win-win going forward. And so some of the things that came out from this meeting is that Texas currently has roughly 2,200 licensees and 300 firms registered there. Texas reached out to 31 states that have some form of certification. California was the first state that they are working with to get an agreement. Texas accepts provisional licensing, meaning you can work in Texas until you pass the test. And they also have an apprentice category for a new reporter who would need to keep trying to take the test while working under an experienced reporter. The RPR uses the same testing standards. I'm sorry, the Texas test uses the same standards as the RPR, the 180 literary, 200 jury charge, 225 Q&A at 97% accuracy. Texas does not use the RPR for their testing standard. They give their own test. And their reasoning was twofold. One is because the RPR is allowed to be passed in legs, and also because the RPR is given by a test itself is given by an association, versus in Texas, their law requires certification by a jurisdiction. The Texas exam is developed by the association's testing advisory committee. I will mention that. The CRB has entered into an interagency agreement with the Office of Professional Examination Services to help determine if the Texas license exam is comparable to the California exam. We have also asked them to look at the NCRA's RPR for the same purpose. When all the information is received, the results will be discussed by the task force and a recommendation will be made to the board.
Excellent. Thank you for that report out. Let me see. Are there any questions from the board or thoughts, comments based upon what we've heard thus far. I don't see any hands raised. Let's see if there are any public comments on your report out.
This is the moderator. I have opened the Q&A panel. If you would like to make a public comment, please click on the Q&A icon on your screen, type "I would like to make a comment" into the ask field, and submit that to all panelists. At this time, we do have a couple requests. Our first request comes from Mike Hensley.
Welcome, Mr. Hensley.
Mike, your line is open. You will have 2 minutes.
Good morning. This is Mike Hensley, president of CCRA. And I would like to bring to the board's attention that CCRA is disappointed to not have been included in the task force discussion. Even with CCRA indicating its interest in being a participant at the May 21 meeting, it's also our understanding that there was communication with a member of our board to be a participant on this task force, and somewhere the lines of communication were dropped. CCRA would ask for follow-up in that aspect for improved communication and inclusivity to any future discussions. In light of that absence, I would like to bring forward the following points. At the May 21st meeting, member Heather Bautista, quote, requested clarification on how to determine which state's minimum transcript format standards to follow for remote proceedings, unquote. And Chair Hurt also replied that, quote, the details would be fleshed out, unquote. And CCRA would ask, have those details been fleshed out to answer that question? Additionally, Ms. O'Neill questioned, quote, how the different state boards would handle enforcement issues, unquote. CCRA is asking, have those issues been addressed? Thank you.
Thank you. Next commenter.
Our next request for comment comes from Heather Bautista. Heather, your line is open. You will have 2 minutes.
Thank you. I just wanted to state my request for clarification. I also am a licensee of the state of Texas as a certified shorthand reporter. I was granted endorsement for my machine portion because of my experience, because of my certifications. But I did have to take the written knowledge test for Texas. And I think that that is an important aspect that needs to be highlighted by the board, because I just heard about reciprocity. I am all for reciprocity with the state of Texas with granting endorsement of their machine, their practical knowledge on the machine. But I do think it's important that anybody that is granted that also be required to pass the written knowledge portion for the California specific codes and procedures that we have. Thank you.
Thank you. Do you have additional comments?
At this time, we have no additional requests for comment. I will close the panel.
Okay. I also see Ms. Duarso's hand raised. Could she lower it if she does not have a comment? Perfect. Thank you. That helps me. Thank you very much. So now I'll bring it back to the board. Are there any other questions or comments based upon what we've just heard from the public? Okay. I do not see any. And I don't see our executive director's hand raised. So this is just an informational item. There's no board action required. I want to thank both board member Sunkeys and O'Neill for working through this issue. And I think it's really important that OPS analyzes the tests and we can really get data and make a decision on facts and not just beliefs. So as I understand, they're really digging into the process and putting those tests side by side. We did hear some public comments with regards to some of the finer details, and both committee members have heard those requests, and so I'm sure they will take them back to the committee and talk about them. All right. This is this would be a serious change. We've never had license reciprocity, so there's a lot of work going into this, and we appreciate that. It's going to take a little bit of time. All right, I am now going to move on to agenda item number 8. This is legislation, and I believe this is where Ms. Finner will take over.
Thank you, Madam Chair. So the first thing I wanted to report back on is AB 1469, authored by Assemblymember Lowe. It did not make it out of the Senate Appropriations Committee due to the shortened legislative year and the priority that was given to COVID-related legislation. The Court Reporters Board is very appreciative of the continued efforts that Assemblymember Lowe is doing to move the registration forward on behalf of the California consumer. Does anyone have any questions on that particular bill?
No, I'd just like to also send my thanks to Assemblymember Lowe for working really hard to get this before the other legislators, and we look forward in the future working with you to get registration through. We think it's an important part of the board's agenda and strategic planning for the future. That's all.
The next item up is 8.2, which is the Senate Bill 1148, authored by Senator Umberg. This became law in September. I am trying to make it clear to everyone that the only thing that changed with this law was the requirement of the court reporter to be in the physical presence of a party witness, period. That is the only thing that changed. So despite the rumors going around on social media, despite what other reporters are telling you, doesn't matter what the word is on the street, so to speak. The law only changed the physical requirement to be in the party presence of the party witness, excuse me. That is the only change. So all of the misinformation that's gone out on social media has prompted more phone calls to our office than any other issue that I can remember. The social media accounts seem to be saying that with the passage of SB 1146, anyone can report any depot anywhere, and that's not true. Again, the only thing that changed is the requirement of the court reporter to be in the physical presence of a party witness. So pre-COVID, if the deponent was in California, we have law that says that you have to be licensed by the CRB in order to report that deposition stenographically. Then there's a million what ifs. Well, what if it's a federal case? The answer is federal rules apply, and the court reporters the Court Reporters Board has no jurisdiction over federal cases. What if it's a Georgia case with Georgia attorneys? And the answer is if the deponent is in California, just like pre-COVID, you must be licensed by the CRB in order to report that deposition. What if it's a California case and California attorneys, but the witness is in Texas? So the CRB is fine with that, but what about Texas? I don't know Texas law. I'm guessing that they have the same type of law that would require licensure in their state to report a deponent that's located in Texas. So it seems like people are making it more complicated. I'm just saying thank you to staff who is working through the endless variations, and they've had a lot of patience with the same questions coming in. Hopefully we've answered them here and also in the newsletter, but I would encourage anyone that's still confused to go ahead and give us a call. Do the board members have any questions?
I do not, and I don't see any hands raised. Thank you for clarifying. It's interesting how a statement can get out and it works like wildfire and it makes its way everywhere. So I appreciate you just writing that and making it clear exactly what we have in this law.
Would you like to take public comment on those first two bills before we move to the proposal?
That's exactly what I was going to do. So let's now move to public comments to see if on these two agenda items there are any public comments.
This is the moderator. If you'd like to make a public comment, please click on the Q&A icon on your screen. Type, I would like to make a comment in the ask field and submit that to all panelists. At this time, we have a request for public comment from Mike Hensley. Mike, your line is open. You will have 2 minutes.
Good morning. This is Mike Hensley, president of CCRA. And at the May 21 meeting, in relation to the discussion regarding the Texas reciprocity, Chair Hurt inquired, quote, if a practicing California CSR is required to be physically located in California, unquote. And Ms. Fenner responded that, quote, that is the expectation under the current law, unquote. Since that time, we have had the emergency order issued, followed by SB 1146, which has now codified a change to CCP 2025.310. During this time, membership has been making inquiries both to the CRB and also their local associations, trying to define an answer to the question, where does the court reporter need to be physically located while performing remote proceedings? CCRA is asking the CRB to define clearly what should be the location of the court reporter physically while handling remote proceedings. We're asking that this be done in writing to avoid the myriad calls that are coming in both to the CRB and to the association offices, also to avoid inconsistency in information that is disseminated verbally. Thank you.
Okay, thank you. I see Ms. Dorso's hand raised.
Yes, she is our next commenter. Ms. Diorso, your line is unmuted. You will have 2 minutes.
Thank you, Madam Chair and Board. I just wanted to clarify that on AB 1469, it's my understanding it's not just because of COVID that it was sent to suspense. In fact, on August 11th, the Senate Appropriations Bill analysis stated that the fiscal impact of this bill is related to the civil and criminal penalties provisions is unknown and dependent on numerous factors unique to each case. As the crime expanded upon by this bill is punishable as a misdemeanor with potential for incarceration, certain rights to the defendant are attached to the proceedings at public expense if the defendants are unable to afford the cost of representation, which could lead to lengthier and more complex court proceedings. Consequently, the court adjudicates a small number of these new crimes that would otherwise have been filed or resulted in criminal action. The gist is the court cost of this bill would likely surpass the suspense file threshold. And I just wanted to make that point, that it's not just because of COVID that 1469 was put to suspense. Thank you.
Okay, do we have any other public comments?
That is it at this time.
Thank you. Bring it back to the board. Ms. Finner, do you have, yes, I see your hand raised. If you could please respond.
I just wanted to point out to President Hensley that it doesn't matter where the reporter is. The location of the deposition is where the witness is.
Thank you, Ms. Finner. Okay. Any other questions, thoughts from board members? Let's now take it then to item 8.3. Proposal from CalDRA to amend Business and Profession Code Section 8018 regarding use of the terms court reporter and deposition reporter.
I don't have anything to add to the information that was provided in the board book. I would assume that there's somebody from DRA that would like to speak to it.
Okay, thank you. Do we have a representative from DRA who would like to speak to this item? I do see Ms. Pallone. Let's see. So I don't believe There is a representative stepping up. Everyone has the brief summary before them. The recommendation by staff is to appoint a subcommittee to work with CalDRA and interested stakeholders in finding an author for this legislation.
Madam
Okay.
Chair,
Oh, yes.
I
now
believe
see-
a Representative Mary Pierce has her hand raised, and I believe she's a representative from DRA.
Excellent. Okay. Welcome, Ms. Pierce. If we could unmute her and then give her an opportunity to speak to this item.
She is unmuted.
Okay, we've got about 10 minutes.
Yes, I actually, Tony Pallone is on the call and I don't know why she hasn't raised her hand, but she has some prepared remarks on behalf of the DRA that I'm hoping you can unmute her perhaps and she can go ahead with her presentation.
This is the moderator. Unfortunately, it is showing that she does not have an audio connection.
Okay, well, then how about if I just try to wing it? I actually didn't prepare for this, but I am very familiar with the writing that we sent to you detailing why we think that this is important. And quite frankly, it dovetails right back into item 6 about digital recording. And that we have been presented with examples of digital recorders that are calling themselves court reporter and deposition reporter out in the field. And we do believe that this leads to a misunderstanding on the part of the attorneys about whether they are licensed or not and governed by the board that uses the term court reporters board. And we believe that anyone that is using the title court reporter or deposition reporter, that those terms be added to the restrictions of not being allowed to call yourself a certified shorthand reporter or a CSR. We think that this will go a long way to enlightening the attorneys about who's licensed and who's not, which equipment they're using, which process they're using, and to, you know, help alleviate any fraudulent misunderstandings about whether someone is licensed or not in their performing of these duties. And we want to thank the staff for their recommendation of our proposal. And we ask and hope that the board will see its purpose and its benefit to the consumer and to the protection of the consumer.
Thank you, Ms. Pierce. I would just say to Ms. Pallone, and maybe I'll turn to the moderator, there is a call-in option. You can use your phone, correct?
That is correct.
Okay. Is that number on the screen for all to see?
No, that is something that would have been on the meeting agenda.
Okay. So if Ms. Pallone would like to speak, uh-oh. Ms. Finner, do you have it quickly before you? I thought I did. Let's see what that number is. Or Ms. Bruni?
The audio conference is 1-415-655-0001. And then there's an access code of 146-896-7986.
Okay, thank you. So we'll go to our next public comment, and hopefully Ms. Pallone can call in so she can give her prepared remarks. I see just one hand raised, Ms. Dorso. Could we hear from her, please?
Yes,
Welcome.
am I unmuted?
You are now, yes.
Okay, thank you, Madam Chair and Board. My name is Kimberly Durso. I'm president of the Protect Your Record Project. The Protect Your Record Project, along with independent stenographic court reporting advocates, spoke on the issue of title protection at the last CRB meeting. We reiterate today that the title court reporter should be a title protection belonging solely to certified court reporters, CSRs, who have been historically for decades identified in the legal field as court reporters. Attorneys polled by the Protect Your Record Project express that it is unequivocally expected that when a court reporter is ordered, that they expect a certified stenographic court reporter, not a notary public posing as one. Attorney Alex Hernandez stated, when I ask for the services of a court reporter, I expect exactly that, a shorthand reporter certified by the state of California. I would be unhappy if a digital recorder showed up instead. It is imperative that a professional CSR be responsible for the transcript and its accuracy. Attorney notices bolster Mr. Hernandez's point as evidenced by deposition notices like this one that state, quote, the above referenced deposition will be taken before a certified shorthand reporter, court reporter, and the witness may be sworn in by the court reporter who will record the testimony by stenographic means. PYRP believes this court reporters board has not protected California consumers, unfortunately, by not enforcing against notary publics who fraudulently use the title court reporter. This board says it will only enforce if the notary public calls themselves a certified shorthand reporter. This is wrong and tone deaf for the reasons stated above. And this very board renamed itself from the Board of Certified Shorthand Reporters to the Court Reporters Board and uses the title court reporter repeatedly in the majority of its publications. Consumers deserve clarity. Consumer harm is risked when unqualified recorders show up. CRB, please, it is time for you to be accountable to the consumers of California on this issue. Your contradictory language and ambiguities, even in your own title and publications, have allowed this fraud
30 seconds
to exacerbate. Court reporter is a hard-earned title that stenographic CSRs have professionally trained for and deserve to have protected. And we helped not sunset you, and we hope for you to work on this issue immediately. Thank you.
Our next request for comment comes from Heather Bautista.
Thank you. Welcome, Ms. Batista.
Heather, your line is open. You will have 2 minutes.
Thank you. My name is Heather Bautista. I'm a licensed certified shorthand reporter. My license number is 11600. I want to first thank the Court Reporters Board for putting such an important item on the agenda, title protection, which could also be known as consumer protection. I'd like to add one request to that of CalDRA. I would like, in addition to having language specifying court reporter and deposition reporter, to request that deposition officer also be protected. You are a board that governs how we as licensed certified professionals are to conduct ourselves while performing our duties under the California CCP. You collect our yearly licensing fees, which we readily pay in order to perform an integral part of the justice system in this state. To turn a blind eye and shrug your shoulders at the rampant, blatant, widespread fraud being perpetrated on consumers of this state by corporations and persons in violation of BMP 8018 is insulting. The Court Reporters Board of California issued my license to me on January 14, 1998. I started court reporting training my senior year of high school in 1990. It took me 7 years to get through the training, the practice, the speed building to finally qualify to take the May 1997 CSR exam. I passed the English exam and the professional practice exam on the first go. Those were tests I could study for. The dictation exam, I failed the first time. This is a test, as you well know, that determines how well we can write with our nerves running haywire for a specified graded 10 minutes. I say this to highlight the difficulty that we face when being tested to become licensed court reporters. Rightly so. This is what we do. We don't simply press record, monitor microphones, and depend on electronic recording to capture a record.
30 seconds.
We depend on our skill, our human brain, our impartiality, and our ability to determine what is and is not understood. I ask you to support and seek legislation that gives us title protection. The consumers of California deserve it. But even more so, as board that collects our licensing fees, you owe it to all of us to do the job of protecting the consumers as well as your licensees. Thank you.
Thank you. Do we have any additional public comments?
Yes, our next request for comment comes from Kim Kazora. Kim, your line is open. You will have 2 minutes.
Thank you. I'm Kim Kuzora, CSR 8509. My statement again will be related to the documents I provided to the CRB that are in the agenda packet. Attorneys have a reasonable expectation that when a deposition notice says the depo will be taken before a certified shorthand reporter or a certified court reporter, that a licensed certified shorthand reporter will be stenographically recording the deposition transcript, and the transcript will be admissible in a court of law. In Attorney Roger Cartosian's March 2020 email that I submitted, he refers to the use of the title court reporter by anyone but a licensed CSR as a deceptive practice. Mr. Cartosian's reasonable expectation is that a person who shows up to report this deposition is licensed and has gone through extensive education and training. A person who shows up who does not have that education and training and represents themselves as a court reporter is a fake and a fraud and cannot be tolerated in a judicial and/or administrative proceeding. Court reporting legislation bill analyses also show that even the California legislature assumes court reporters are all licensed certified shorthand reporters. AB 1520 and AB 1469 bill analyses state that court reporters are highly trained professionals who stenographically preserve the words spoken in a wide variety of official legal settings. Also stated is, quote, in California, a person must be licensed to work as a court reporter and state courts are to act as a deposition officer. The board's own supporting statement for their sunset bill says, quote, licensed court reporters, unquote, are charged with producing an accurate and timely transcript of legal proceedings. Charged with oversight of the court reporting industry, the board ensures protection of the California consumer and their essential legal rights. Similar statements are also in the background papers and sunset review reports for the CRB. All of these examples leads consumers to believe that anyone who calls themselves a court reporter is a licensed certified shorthand reporter that is under the jurisdiction of the CRB. Business and Profession Code 801A8 has title protection for the term certified shorthand reporter in
30
CSR.
seconds.
The board changed its name to the Court Reporters Board from the Certified Shorthand Reporters Board, and the term court reporter is used repeatedly on the board's website and publications. It only makes sense that there should also be title protection for the term court reporter to protect consumers. I urge the board to support this bill. Thank you.
Thank you.
Our next request comes from Janet Harris. Janet, your line is open. You will have 2 minutes.
Thank you. My name is Janet Harris. I am president of the American Association of Electronic Reporters and Transcribers, and we oppose the proposal offered by CalDRA. There are multiple technologies for preserving testimony and producing verbatim transcripts: digital, machine shorthand, voice writing, and video. Each has a recognized national organization certifying a person's proficiency to preserve and produce a complete and accurate record. The Court Reporters Board was formed to regulate only certified shorthand reporters. Changing the board's name does not broaden its scope. Court reporter and deposition reporter are terms of art and not specific to a particular technology. Reporters using machine shorthand do not have exclusive rights to the term court reporter. This proposal is anti-competitive and impacts mostly individuals and small businesses at a time when the state and the entire country are facing huge shortages of court reporters. Adding barriers to entry will only exacerbate and further restrict the use of other technologies to fill the void left for consumers due to the steno shortage that shows no sign of rebounding. The vast majority of consumers of court reporting services are attorneys and judges who are well-informed and discerning consumers. They are not here today asking for your oversight. Both the Secretary of State and National Certifying Associations have oversight over reporters using the various technologies, and a third level of regulation is not necessary. This proposal does not solve a problem. In fact, it intensifies California's shorthand reporter problem, and it creates a new problem for all of the current users of digital recording technology here in California, including many state agencies, municipal courts, superior courts, all who have relied on these services for decades to ensure the efficient administration of justice. We urge you to reject this proposal, and we will submit a written statement to supplement my comments here today. Thank you.
Thank you.
Our next request comes from Mike Hensley. Mike, your line is open. You will have 2 minutes.
Thank you. This is Mike Hensley, president of the California Court Reporters Association. And speaking on behalf of our entire stenographic membership, we are interested in participating in the furtherance of this endeavor, both through discussion and processes otherwise. Thank you.
Thank you.
We now have an additional comment from Janet Harris.
Have we taken all comments? I think she's responded before.
Yeah, and Ms. Heather Bautista has requested to make further comment as well.
Okay, I'll give both of those commenters a minute, and then we should move on to board discussion.
Okay. Ms. Harris, your line is open. You will have 1 minute.
Actually, I just put an entry in to speak in both the all and the Q&A, so I've completed my comments at this time.
Okay, thank you.
Thank you.
So let's check in on Ms. Heather Bautista. Your line is open.
I appreciate the opportunity to supplement what was my last statement. I just had one more point that I wanted to raise. I was looking over the statistics provided of the pass rates for the CSR exam over the last 12 years, and a few things jumped out at me. For the dictation tests alone, an average pass rate over the last 2 years is 16.87%. 5 years was 16.87%. This is a difficult test and a difficult license to obtain. Not everyone who takes these exams is passing, obviously, and not everyone who wants to claim the title and respect of being a court reporter should be able to. I've been a court reporter for over 22 years, and I'm still learning, honing, perfecting, sharpening my skills so that when attorneys see me appear at their depositions, they can rest assured that they will have an accurate record of proceedings prepared by someone who has an ethical obligation and a professional obligation to do so. Thank you for allowing me to supplement my comments.
And we have one last request for comment from Kimberly Dierso. Kimberly, your line is open. You will have 2 minutes.
Actually, she spoke earlier as well. So since this is our second time around, could we have a minute, just as we did for the other speaker?
Yes.
Thank you.
Am I unmuted?
You are.
Okay. Kimberly Durso, President of Protect Your Record Project. I find it telling to hear that the president of AART wants to promote the perceived shortage notion because they are pushing the digital recording agenda. That is a perceived shortage. We've realized through remote reporting because of COVID how great stenographic reporters are able to cover calendars. If you want to be called your own title, then go and be trained in your own title. That does not, in my belief, give you the right to use the term court reporter. We have trained hard for that. We deserve that. And if you're relying on the Ducker report, that is outdated and no longer relevant. And this is just an agenda for corporate entities to make more money. That's it.
And I see no more further requests for comment at this time. Would you like me to close the Q&A panel?
Yes, please. Thank you very much. Okay, I will bring this back to the board for discussion, thoughts, comments. Who would like to start us off in this discussion? And if you could just use a raise hand function. You know, and I'd like to say there's been a lot of comments so far, and you know, I want it to be clearly reflected in this public forum that, you know, our board members are individuals who care a lot about this profession. We spend a lot of time working and going through these packets to do what we think is best. We have 2 court reporters and we have 2 attorneys actually on this board, and so we are thoughtful and knowledgeable, and we definitely take the mandate to protect California consumers very seriously. You know, some of the comments I've heard has tried to say that we're ignoring or we don't want to do our job, and in fact, it's the exact opposite. We're taking the mandate by the legislature and doing our best. So here's to the board. Thank you, Board Member Sunkeys. Could you please state your thoughts on this proposal from CalDRA?
I would move that we appoint a subcommittee to work with CalDRA and interested stakeholders in finding an author for this legislation.
Okay, there is a motion. Is there a second?
Second.
Thank you. Any other discussion? Let's move it. I see Board Member O'Neill. Yes.
Oh, I didn't take my hand down, sorry.
Oh, okay. Okay. No problem, no problem. Okay, so let's take public comment on this motion in second.
Excuse me, Madam Chair. Was the second by Ms. Nocella or Ms. O'Neill?
I believe it was Ms. Nocella.
Correct.
Thank you.
Do we have any public comments on the motion?
This is the moderator. I have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon, type "I would like to make a comment" into the ask field, and submit that to all panelists. At this time, we do have a request from Heather Bautista. Heather, your line is open. You will have 2 minutes.
Thank you. I just wanted to request to be invited to participate in the committee, if possible, for this, looking for the author for this legislation. I also hope that PYRP will be contacted as well for their input. Thank you.
Thank you. Any other public comments?
Yes, our next request is from Janet Harris. Janet, your line is open. You will have 2 minutes.
Thank you. With regard to this subcommittee and finding an author for legislation, much of what I hear is misinformation about any other technology other than machine shorthand, and I would highly encourage that the board take some time to educate themselves on the certification process, the training programs that are being implemented in schools throughout the country, and to have a clear understanding of what the other technologies are doing before they make a final decision. Thank you.
And we have one last request from Kimberly D'Urso. Kimberly, your line is open. You will have 2 minutes.
Thank you very much. Kimberly D'Urso, President of Protect Your Record Project. And thank you, Heather Bautista, Protect Your Record Project. Would very much like to be included in the conversation as well. Chair Hurt, your comment is noted, and are any comments made by us are not personal to you. We do understand that you guys are doing your best. We just would really like to see some clear language and ambiguities cleared up regarding court reporter and CSR in the board's own publications, which seem contradictory. Thank you.
Seeing no additional requests for comment, would you like me to close the panel?
Please. Thank you very much. And then I guess I'll just make a couple of comments. I know we have a motion and second on the table, but to the point of further discussion, you know, I would like to understand the topic more, but all we're talking about right here is protecting the terms court reporter and deposition reporter, and it does not preclude work that's done by other means. You know, I can't speak to the changes that was made to the name many, many years ago. It seems that was a decision that someone has to go back and look at the history of that, but it's the name that we have. And so I think it's an appropriate step forward to appoint a subcommittee to work with CalDRA and interested stakeholders to protect those names. I think even at the bar, they went through that same process of attorney and and counselor and what those names mean. So I think it's a good next step, and I can support it. So to that, let's do the vote. Ms. Bruning, if you could call the vote.
Thank you, Ms. Nocella.
Aye.
Thank you, Ms. O'Neill.
Yes.
Thank you, Ms. Sunkeys.
Yes.
Ms. Hurt.
Aye.
Thank you. Motion carries.
Okay, so we have created this subcommittee. Now we need members. And I see Ms. Finner's hand raised. Ms. Finner, would you like to comment?
So the subcommittee is appointed at the pleasure of the chair. So by subcommittee, we're not talking industry-wide. It's not a task force like that's what we've done more recently. Subcommittee is the person that's going to act on the board's behalf in between minutes. So person or persons, I should say. So I just wanted to make it clear to the chair and the public that what you're doing right now is appointing your subcommittee chair, not the full subcommittee. We will work with interested stakeholders, but you're not appointing a larger subcommittee that includes that wide universe.
Yes, thank you for clarifying. So I'm now going to turn to our board members and see who would like to serve as the chair of this subcommittee. Unfortunately, Ms. Nocella is not in the running, so I'm looking at board member Sunkeys and board member O'Neill right now. Any takers? All right. Board member Sunkeys, hand raised. Any thoughts? Oh, you'll take it. Okay.
I'm sorry. I thought
well.
I'm sorry. I thought I had raised my hand earlier. If it's not a raised, I meant to raise it.
Okay, perfect. We're very happy that you're taking this on. I don't see any other hands, so I think you're the best person for the job on this one, for sure. Okay? All right, so at this point, I'll appoint Board Member Sunkeys to head off the subcommittee. And as been stated earlier, she will work with staff to find other interested stakeholders to sit in on these convenings and meetings. Thank you very much, board. All right. I don't believe there are any other items under 8. So we will now move to agenda item 9, which is regulations.
This will be presented by our regulations attorney, Danny Rogers.
Good morning, everyone. This is Danny Rogers, Regulations Counsel to the Board. We have 3 items and 2 sub-items under this item 9. The first is the AB 2138 package. The status report for sections 2470 and 2471 is we anticipate filing this package with the Office of Administrative Law shortly. The agency approved this on November 16th, and we just have a couple of follow-up items to wrap up, and we'll be filing that. Item number 9.2, the disciplinary guidelines, those were before you at the last meeting. The proposed amendments to 2472 were voted upon, and we are awaiting preparation of this package from board staff. The next item, 9.3, inspection of examination papers, section 2422. This language is before you for a vote. And I'm open for any questions on that package if you have any questions. And finally, item 9.3.2, section 2418. This language is before you for a vote.
Okay, thank you very much. Let's turn to the board and see if there are any questions at this time based on what you just discussed. We've got the first 2 are actually just information, but that which is the license examination, there's definitely a decision there that needs to be made on those changes. I see Ms. Finner's hand raised. Yes?
Yes, I just wanted to clarify that we're going to be voting on 2422 only, and that 2418 is going to be amended, and we'll be back before you for the next board meeting.
Okay, thank you for that. Okay, board members, so we're just taking into consideration right now 2422 inspection of examination papers. I think this goes to the appeals process discussion. Okay, are there any hands raised, any questions folks have for Ms. Rogers or more Ms. Finner? Okay. All right, I will now turn to public comments.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon on your screen. Type, I would like to make a comment into the ask field and submit that to all panelists. We will pause for a couple of moments for submission.
Okay, I don't believe I see any hands raised.
Seeing no request, I'll close the panel.
Thank you. All right, this is back before us. We have, again, 24, 22 inspection of examination papers. We're basically editing because we're using the online testing platform. So some of those early considerations are not available for online testing. I don't see any hands raised. Okay, well, there we go. Board Member Sunkeys.
I would move to approve the proposed regulatory language to amend 16 California ADC 2422. Additionally, move to direct staff to proceed with the pre-approval process for the regulations with authority to make non-substantive changes. If no substantive changes, staff is then directed to submit the regulations package to the Office of Administrative Law.
Okay, thank you very much. So we have this motion. Could we please have a second?
This is Board Member Nocella. I second, and I applaud Board Member Sunkey's very thorough motion. That was well done.
There's no question in that motion. Thank you. Okay, we've got a motion, a second. I'll turn it to public comments and see if there is any further discussion on this item before we take it to a vote.
This is the moderator. We have opened the Q&A panel for requests for public comment and are displaying instructions on the screen. We will pause for a moment to allow time for submission of requests.
Okay.
Seeing none, I will close the panel.
Thank you. Ms. Bruning, could you please call the vote?
Thank you. Ms. Nocella?
Yes.
Ms. O'Neill? Moving on, Ms. Sunkeys?
Yes.
Ms. Hurt?
Aye.
Motion carries.
Thank you. So the time is now 11:30. I just want to turn to the board. We do have our next board policy manual. Would you all like to move forward with that or take a lunch break now? What suits you?
I'm fine with moving forward if anybody else disagrees.
I agree with you. Okay. All right.
Staff is okay to move forward.
Excellent. Thank you. Thank you very much. So we'll continue then on to agenda item number 10, which is board policy manual. This is a discussion and possible action to update the board policy manual, repeal policies already contained in regulations and otherwise duplicative. Is there a staff presentation?
Yes, thank you, Madam Chair. Just like we are updating our regulations to conform with the online testing, likewise, we are going to be updating our board policy manual, which is kind of how we do things until we figure it out. Then we'll forward into putting that into regulation because it's such a new process, but we at least want policy so we're consistent. So the first policy is on page 58, and it addresses the appeals committee members. So without an appeals process, there's no need for a committee, and the recommendation is to repeal. I recommend taking these one at a time just to make it might seem like it's slowing it down, but there's such separate issues, I think it might make it faster in the end.
Okay, let's do it that way, to be clear.
So just to be clear, staff recommendation is to repeal the appeals committee members portion of the board policy manual.
Okay, is there a discussion on this item? Any questions you have? I think we all are aware that this is happening because of the online testing version that we have before us. Okay, so let me then turn it to public comments and see if we have any public commenters.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon on your screen. Enter "I would like to make a comment" into the Ask field and submit that to all panelists. Our first request for comment comes from Mike Hensley.
Thank you.
Mike, you are unmuted and we'll have 2 minutes.
Good morning. This is Mike Hensley, president of CCRA. And for this particular element, I am speaking on behalf of our membership population comprised of students and educators in the stenographic profession. There is a great and intense concern amongst our membership community regarding the removal of an appeals process as part of the online examination. If California is to maintain the high standard of accuracy required to pass the exam, then an appeals process must be included. This is especially crucial given the nature of subjective grading that in several cases in the past has been appealed and has led to the successful licensure of an appellant. Recognizing that there are changes to the examination process by moving it to the online platform, CCRA would strongly recommend the board consider updating the appeal process to reflect current standards as opposed to entirely removing the appeal process. Thank you.
At this time, we have no additional requests at this time.
Okay. Thank you. All right, I will now bring it back to the board. This basically is an amendment of the appeals process because of the online testing that we are doing. Are there any comments from the board on this item? Just raise your hand. I think I understand some people's reluctancy for this change. In the end, because the online platform and the bank of tests that we currently have, I do think it's appropriate. And as I understand, and Ms. Finner, maybe you can expand a little bit on that grading process and how many times it's looked at. There are different people that chime into the grading, as I understand.
Thank you, Madam Chair. So the initial grading is done, just the words, if you will, is done by the computer. That's pretty straightforward. But because of the differences in punctuation and the differences in how to set up colloquy when you have 4 different speakers going in and out of questioning, there are a lot of different styles. So recognizing that, the board has added a 3-layer human grading process to that. The first person goes through and basically rechecks what the computer has graded. They're looking at formatting and they give back points for anything that the computer has taken off because it doesn't match the words and the style provided to it in the grading document. So they have the first human touch on it. If they come within 20 points, then it's given to a second human grader who rechecks it. If it comes within 10, it goes to a third human grader who rechecks it again. If there's any question that a piece of punctuation, for instance, is not absolutely essential, it always goes in the favor of the candidate. I can tell you in this process, as a result of using that, there was no one at the last test that was within 20 points after it's gone through all 3 graders. So nobody was a wobbler. Nobody was even eligible to appeal under the old appeal rights.
Okay, well, thank you. As I had assumed, there are many layers of review. There's an objective standard and even a subjective one several times there over on the review of the test. So there is almost like an appeals process built in, because it's not just dependent on the computer and its assessment, but additional human graders. Okay, so thank you very much, Ms. Finner. Are there any other board questions, comments, or thoughts? I don't see any hands raised. So could we please, could someone make a motion to either support or deny the staff recommendation? You can just raise your hand. Thank you, Board Member Sunkeys.
Yes, I would move to discontinue the appeals committee from the current board policies. I guess, I'm sorry, let me rephrase that. Move to repeal appointment of an appeals committee from the current board policies.
Correct, and it's been recommended by the staff that the printing policy should stay as it should for exam security considerations. So we have a motion. Oh, and
I'm sorry if I could interrupt, Madam Chair.
Absolutely.
We're not following exactly the board book at this point. I think since putting it out, I think we should take each individual item separately as a separate motion. So this would only address what Board Member Sunkeys put forward, which was the repeal of the appointment of an appeals committee.
So the motion is repealing the appointment of an appeals committee, and I'm looking for a second.
Second, it's Carrie.
Okay, thank you, Ms. Nocella. Okay, let's take this to public comment and see if there are any additional public comments or discussion.
This is the moderator. We have opened the Q&A panel. Instructions are displayed on the screen for your use. You'll pause for a moment to allow time for submission.
Thank you. Okay, I don't see any hands raised.
We have a request from Kimberly D'Urso.
Okay.
Kimberly, your line is open. You will have 2 minutes.
Thank you. I just had a quick statement that I wanted to support and thank President of CCRA, Mike Hensley, for speaking up on the appeals process, and that the Protect Your Record project supports those comments. Thank you very much.
Seeing no other requests, I will close the panel.
Thank you. Bringing it back to the board, we have a motion and a second. Further discussion amongst the board members. I see Board Member O'Neill's hand raised. And it's not raised anymore. Thank you, Ms. O'Neill. Okay, Paula, could you please call the vote?
Thank you, Ms. Nocella.
Yeah, aye, sorry.
Thank you.
Having problems.
Ms. O'Neill.
You're unmuted, Ms. O'Neill. Oh, you're back. You're mute. Okay, now you're unmuted again.
This is the moderator. Unfortunately, we're not able to hear her when she's unmuting her microphone, and I'm not sure why.
Okay.
Ms. O'Neill, can you give me a thumbs up? That's an aye. Thank you, Ms. Sunkeys.
Aye.
Thank you, Ms. Hurt.
Aye.
Motion carries.
So I'll just quickly ask the attorney if a thumbs up is enough for an aye.
I'm sorry, Chair, could you repeat that, please?
Yeah, so we were unable to hear Miss O'Neill, and so she voted with a thumbs up. Is that?
That is satisfactory as long as the note taker is able to dedicate that as an affirmative vote.
Okay, thank you.
Thank you.
I think my mute is off now.
Oh, yep, you're back.
So, aye.
Thank you.
Noted. Thank you.
Thank you all. So then the second.
Thank you, Madam Chair. The second policy is regarding the results of the skills test in December of 1987, way back in the 1900s. The board went online with their written portions of their test. At that time, they adopted the policy to give the candidates their actual test scores. They adopted the policy of not giving the candidates their actual test scores, excuse me. The recommendation is to similarly move to advising a pass-fail only for the skills portion. So it would, since it's the online administration of the skills test now mirrors the online administration of the written test, then they would mirror in just giving a pass-fail response. So the motion that the staff is recommending is to amend the results portion of the board policy manual to advise skills test candidates of a pass or fail score.
Okay, thank you very much, Ms. Finner. Are there any questions from the board or immediate thoughts? I don't see any hands raised. Straightforward. Let's now, if everybody who's not speaking can mute themselves so we don't get too many background sounds, that would be great. Perfect. So now we'll take public comments. Oh, actually, yes, let's take public comment. Yes, please.
This is the moderator. We have opened the Q&A panel for public comment. If you'd like to make a public comment, please click on the Q&A icon on your screen, type "I would like to make a comment" into the ask field and submit that to all panelists. We will pause for just a brief moment to allow submissions of those requests.
Okay.
Seeing none, I will close the panel.
Thank you very much. All right, so back before the board. Any further comments, discussion, motion? Anything's possible.
I move to approve the amended policies for online skills portion of the license exam to include time to upload steno notes, time for second try, and acceptable pass rate.
Excuse me, Madam Chair. It's my fault for creating confusion when I put the board book together, but right now we're only addressing the portion that does the pass-fail notification for the results portion, which is about midway down on page 58.
Right.
I apologize for creating that confusion.
No problem, no problem. Ms. Nocella, we're now at the results section on 10.1. So if you could,
I'll amend the motion. I'm sorry, it's at page 58.
Yes, midway results section, staff
Okay,
to
I'm on the
discontinue.
agenda. I will amend my motion. Sorry, but I can't get to that page. I'm on the agenda. Hold on. There we go. I will amend the motion to approve the repeal policies already contained in the regulations and otherwise duplicative. Is that broad enough, or do you want more specific?
I think we're more specific on the results section, which is the staff to discontinue the practice of it by, yes, that one.
Madam Chair,
So
if I could
recommend that would be great.
So staff's recommendation is that the motion should be to repeal, or I'm sorry, to provide the test candidates notification of pass-fail for their score.
Wait a minute here. But we're still on the results section, correct?
Correct.
Staff to
Correct.
discontinue
So-
the practice of advising examinees as to their scores on each segment of the 2 written knowledge portions of the exam. So they will only be notified pass or fail, correct?
So in 1987, when the board went online with the written testing, they adopted the policy of just letting the candidates know it was passed failing for the written portion. Now that we're going online with our skills portion, staff's recommendation is that we use the same notification of pass fail. Policy was to stop giving scores out for the test results and just notify pass fail. The board staff is recommending we do the same to mirror and have one uniform notification process of pass fail for all portions of the exam.
Understood. So it's the 2 written knowledge portions we're kind of eliminating, and we're just saying pass fail for the entire test, period.
No, it's still in portions because they're still taken in portions. So
no, that actually
do you see it, that this policy for staff to discontinue the practice of giving out the exam results, specific exam results, was adopted in 87. It's kind of a negative. So I'm phrasing it as a positive. We just give them a pass fail. This says it's discontinuing the practice. This is done. This was adopted in 1987.
Hi, Yvonne. This is Anthony. Could you just maybe, if possible, just reference the page number that you're on for everyone?
58,
can follow?
58.
Thank you so much.
Of course.
I understand what you're saying now. This was adopted December 1987, the discontinuation of advising examinees, correct? And so the amendment that you would like to make is that we just give pass fail notification.
Yep.
Okay. So was that clear for the board? Maybe the board needs to ask questions. I understand.
It might be cleaner since it's already phrased in the negative here, but where it says it's the 2 written portions, that we include the skills exam with that. So that's the amendment to what's there. I would, in 2020, I would rewrite it and make it cleaner, but perhaps the simplest motion for the board is just to include the skills portion of the exam in the results policy.
Okay. Board members, do you have any questions?
No, to be clear, can Ms. Fenner provide a recommended motion?
I'd be happy to. I would recommend that the motion be to add the skills portion of the exam in the results portion of the board policy manual. The effect of that would be notifying the candidates of a pass fail, just to be very clear.
Yes. Okay, so it's back before the board again. I don't see any hands raised. We do need to decide to either take the staff's recommendation to additionally add the skills portion of the exam to this results portion. Ms. O'Neill, I see your, okay, thank you, Director Sankey. If you could unmute yourself.
Yeah, I'm sorry. Were you calling on me or Tony?
Well, I saw Board Member O'Neill, well, now she's back on mute. She was unmuted, so I wasn't quite sure if she wanted to speak, but.
I would move.
Go ahead.
I would move that we revise the practice of reporting results to a pass fail.
Okay. Miss Finner, does that support? I think you did restate this to say, and we'll add and skills portion, but the end effect is pass fail notification.
Yep.
So
I think that motion will work fine. It's clear to staff, it's clear to the public. The policies aren't going to be around forever as they will eventually move into regulation, but I think it's very clear to everyone.
Perfect. So we've got a motion. Do we need a second? Of course we need a second. Would anybody like to second? Okay, I see a hand raise, a visual hand raise. All right.
I'll second. This is Board Member Nocella.
Thank you. All right, we've got a motion, a second. Now we'll take it to public comments on the motion.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon on your screen. Type "I would like to make a comment" into the Ask field and submit that to all panelists.
Okay, I don't see any hands raised.
Seeing none, I will close the panel.
Thank you. Ms. Nocella, you have your hand raised. Is there something else you'd like to add? No. Okay. So let's please call the vote.
Thank you, Ms. Nocella.
Aye.
Thank you, Ms. O'Neill.
Aye.
Thank you, Ms. Sunkeys.
Aye.
Thank you, Ms. Hurt.
Aye.
Thank you. Motion carries.
Thank you. So now we have the third portion.
So the third policy is regarding printing of rough drafts for the skills test. So the current policy is to allow the candidate to print one rough draft from which to proof their final transcript. A request has been received to allow candidates to print their notes as well as many drafts as they feel that they need. So recognizing that it's easier to proofread on paper than on a computer screen, the board had adopted the recommendation to allow the candidates to print a single rough draft. And the reason it's limited to one rough draft is for security concerns, simply because the more paper you print, the more times you print, the more chance there is that part of that exam could become public. So the staff recommendation, for the security reason, staff recommendation is to leave that policy on hard copy proofing as it is.
So just to be clear, your recommendation is to leave it as it is.
That is correct, Madam Chair.
Thank you. All right, are there any questions from the board? I don't see any. Ms. O'Neill, if you could mute yourself, there's a background noise with your. Thank you. And now I'll turn to public comment to see if we have any public comments on this recommendation.
This is the moderator. We have opened the Q&A panel and are displaying instructions on the screen. We will pause for a moment to allow time for requests to be submitted.
Okay, I don't see any hands raised.
Seeing none, I will close the panel.
Thank you very much. Okay, back before the board, any discussion or comment or motion? And if you'd like to do so, please raise your hand.
I would ask staff counsel if we need to do any action if we're keeping it the way it is.
Okay. Mr. Payne?
Yes, Yvonne, you were going to ask if we needed to do public comment.
No, actually, she asked whether we needed to do a motion to keep it as it is.
If there's no action to be changed, there's no need for a motion.
Perfect. Thank you.
Thank you.
So no one seems to be in disagreement that we leave it as it is. Everybody's on board. If you would like to see something different or disagree with the staff recommendation, this is the time to. Okay, I don't see any hands raised, so then we'll move on. Thank you, Ms. Finner.
The next 10.2.1 and 10.2.2 really didn't need to be split out. Again, I apologize for the confusion. It's one issue. Just as a little bit of background, I would say that candidates are offered an unlimited number of times to hook up to RTC and practice uploading notes and practice the process and going through it. However, that being said, we found quite a number of candidates were unable to successfully upload their steno notes in the 2-minute time period allotted to them. So policy was they would get another 2-minute slot to try that. That two-minute periods proved to be confusing for the proctors. And so since we have enough other issues with the proctors, we thought that we could eliminate this one by just making it 1 4-minute period to upload your steno notes rather than 2-minute periods. So it's kind of a technical change. If anyone has questions, I'm happy to go into it. But we're asking for the board to approve the modification to that from 2 minutes to 1 4-minute.
Okay, that's clear to me. I'll turn to the board. Any questions for Ms. Finner? No, I don't see any. Okay, so let's now turn to public comments. See if there are any public comments on this change.
This is the moderator. We have opened the Q&A panel and are displaying instructions for your use. We will pause for a brief moment to allow time for submission of requests.
Thank you. All right, I don't see any hands raised.
Seeing none, I will close the panel.
Thank you. So again, the staff recommendation is to modify the time allotted to just 1 period of 4 minutes. Is there a comment or motion to that effect? Thank you. Board Member O'Neill, if you could unmute yourself.
Yes. I would move that, I'm not sure if it's staff, but anyway, that the time allowed for uploading stenographic notes should be changed to a 4-minute period. Let me do that again.
If you could repeat it so that Ms. Bruning and all of us can clearly understand
Sure.
your motion.
Ms. Bruning got it. Ms. Bruning got it.
She got it? Okay, perfect. All right, so we got a motion. Is there a second? A second. Can I second it?
I second it.
Thank you, Board Member Sunkeys. All right, we've got a motion and a second. I'll put it before the public again for public comment on this motion.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon on your screen. Enter, I would like to make a comment into the ask field and submit that to all panelists.
Okay, I don't see any hands raised.
Seeing none, I will close the panel.
Thank you very much. We've got a motion and a second. I don't see a hand raised for further discussion amongst the board. So if we could please take a roll call vote here.
Thank you, Ms. Nocella.
Aye.
Thank you, Ms. O'Neill.
Aye.
Thank you, Ms. Sunkeys.
Aye.
Thank you, Ms. Hurt.
Aye.
Thank you. Motion carries.
Thank you. That brings us to 10.2.3 or
Yes.
yes. Okay.
Yes. The board has received a written request from a member of the public to lower the current passing grade of 97.5% accuracy on the skills portion of the exam. The reasoning being offered is that the state bar has lowered its passing grade, and the belief is that the Court Reporters Board should follow suit. I would just note for the board's consideration that if the decision is to make a change to the passing grade, it would require a regulatory change that would take quite some time to implement.
Okay.
I'm not sure if there's a member of the public that wanted to speak to this, if they're still on the attendee list.
All right, let me first see if there are any questions amongst the board members for you at this time. I don't see any hands raised. I'll just ask a quick question of how long has this passage rate existed? Are you aware, Ms. Finner?
I don't know when it was implemented. I don't know that it's ever changed. I mean, as far as it was this rate when I took the test in 1996.
Okay. All right, so this was a public request. Let's see if you were the individual that put this on, if you could please raise your hand in the public attendees section. I'll give you time to speak to this request if you'd like. Okay. I don't see that public member with a hand raised. Okay.
Ms. Hurt?
Yes.
Apparently Mr. Strix was on this morning and then logged off. I'm not sure as to the reasons. I don't know. I just let him know that we're discussing it now in case he logs back on. I'm assuming you'll move forward, and if he gets on, then we'll accept his comment at that time.
Sure. Okay, so I'm going to bring it back before the board, see what folks are thinking on this agenda item as far as lowering the passage rate for the skills portion. Please raise your hand. Okay, Ms. Finner.
I would just ask for the board discussion if you could try to use passing grade, because passing rate actually means the percentage of people that pass the test, and we don't have any control over that. What we're looking for is the passing grade, a change to the passing grade.
Thank you. Thank you. Sorry. Let me be more exact in my words. Lowering the passing grade on the skills portion from the 97.5% accuracy. Thank you, Board Member Sankis.
Yes, without any convincing reasoning for doing this, I don't see a reason to lower our passing grade. And in fact, what I'm hearing from everyone that has spoken so far is a reiteration of not wanting to lower our standards.
True, Board Member Sankis, and with respect to the comparison to the bar, I know that there was a huge equity argument being associated with that change. At this point, we only have an individual who has asserted that this is something we should do. And I really don't have any data or facts as well. And I know, particular to the bar, they had quite a bit of statistical data, not just one individual not passing consideration. So this is definitely not equivalent, I believe. And I see Board Member O'Neill's hand raised. If you could, please.
Yes. I can remember in the 80s where we had not a shortage as great as it is now, but there was definitely a reporter shortage, and this exact issue came up about lowering the pass rate so more people could pass. I didn't support that then, and I don't support it now.
Thank you, Ms. O'Neill. Yeah, I think when the California State Bar also passed, they made a statement that it was not reflecting whether you could be a good attorney or not, the passage rate, and that's why they were advocating for a lower rate. I think with this profession, it's definitely a little bit different. The skills are very straightforward and objective. Much different, I think, than being an attorney. There are skills there, because I remember taking that that bar, and I'm sure Miss Nocello remembers. It's kind of etched in our brain. But the skills are different as it relates to court reporting and deposition recording here. Okay, so I see, yes, board member Nocella's hand raised.
I would have to say that I agree with everything that's been said. Without significant data, I don't think that this is something that we should act on. I will say your comments, Chair Hurt, about the board are very well founded. I will say I personally wasn't supportive of them changing the threshold on the state bar exam. So I know that's not necessarily as relevant in this analysis, but I feel strongly that we should not change the threshold for the pass rate on this profession.
Thank you. Yes, accuracy is important in taking the record, and that's definitely a more objective marker. All right, thank you. If you could lower your hand, Ms. Nocella, that would be great. I don't see any other hands raised, and it sounds like there isn't a motion to change this passage rate.
Madam Chair, would you like to ask for public comment?
Yes, I'm going to move now to, let's see if we have any public comments on this item.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon on your screen. Type, "I would like to make a comment" into the ask field and submit that to all panelists.
Okay. I don't see a hand raised. So we'll continue on. Thank you. There's not a motion on this item. We have taken it into consideration, deliberated on it, and I think it stands that we'll keep the acceptable pass rate as it is for the skills portion of this license exam. All right, I now believe it's time for us to move on to agenda item 11. Ms. Finner, I don't believe, yeah, that's it for on that item.
Correct.
Yes.
The first item for the strategic plan is that the board has already approved language for the publication to educate the attorneys and the litigants on the importance of hiring a licensed court reporter. The final design is on our website, and it's provided in the board packet at 62. It's for informational purposes only. It's just to show what's out and available. Are there any questions?
Okay. Are there any questions with the board? I don't. Okay. Yes, board member Sunkis. Board member Sunkis, I see your hand raised. If you could unmute yourself, we'll.
Sorry, I hit the wrong button. The only thing I would mention is, or suggest, if it's appropriate at this time, is on under B, the first bullet point. I would suggest adding the word "only" after transcription.
I think you're looking at the wrong publication. This is
I am.
62.
I apologize. The page is stuck together. Sorry.
Okay.
That wouldn't
Thank
happen
you.
in an electronic format. I'm just kidding. Thank you.
No.
Okay, so it doesn't sound like there are any comments or questions on, and we're talking about the 5 reasons to hire a licensed court reporter publication. Okay, so let's put it before the public and see if there are any public comments on this item.
This is the moderator. We have opened the Q&A panel. and the instructions are being displayed for your use. We will pause for a brief moment to allow time for requests.
Okay, I don't see any hands raised.
Seeing none, I'll close the panel.
Thank you. Thank you very much. And thank you, staff, for putting this document out. It's beautifully done, and I think it gets straight to the point. And this is a great publication. Thank you for the work on this.
Continuing on to 11.2, that's the best practices task force. That one was also co-chaired by Board Member Funkeys and Board Member O'Neill. And I believe Board Member O'Neill is going to present the report on this time.
Excellent. Thank you. Board Member O'Neill, if you could, please. I see that you're unmuted, but I don't hear you. No, unfortunately.
Now, do you hear me?
Now we can hear you. Excellent.
Okay, sorry. Okay, well, on June 19 of this year, the Best Practice Pointers Task Force met and to take on the topic of remote court reporting. The members, as Yvonne said, was myself and Robin Sunkeys, and then also attending the task force and helping in the development of these best practices was Irene Abbey, Lauren Biggins, Jennifer Esquivel, and Priscilla Gwaltney. And even though it was a small task force in number, we, between the 6 of us, we had decades, et cetera, of experience behind us as we tackled this task. On pages 63 and 64 of the board book, you will find the results of the work that the task force performed. And we will be presenting this where I left it to the board. But before we do that, as a reminder, best practices are not underground regulations. They are created and made available for anybody to look at for more of a guidance than a requirement. So therefore, there would not be any anything that the board itself would do in the sense of enforcement, because of the fact that it is just the best practice. And so at this point, the task force is offering the draft of best practice pointers for the board's review and input. Once we've had once it's approved, then the next step will be to go to legal and have them review it. And then once they approve it, then it will go to the printer and design and layout to have it come forth, something along similar to what looking wise, or something similar to what we just saw as far as 5 reasons, and not that the information is going to be the same, but it will be something to that effect. So at this time, I'll turn it back to Madam Chair for consideration and input.
Thank you, Board Member O'Neill, and thank you to the various individuals that you listed that were a part of this best practices task force. I know when we did this the first time, gosh, I can't even recall. Some years ago, I was on that committee, and it was really interesting to hear all the different aspects and ideas put forward that make a difference in making court reporters stronger in the work that they do. And I think it was well received and liked. And so I'm glad we were able to do a number 11. Before us is staff recommending that the board review this draft and provide feedback and approve the final language. So as Ms. O'Neill said, it can now move on to legal review and then eventually to the board website and made to look nice like the publication we just saw. Okay, I don't see any hands raised as far as questioning the content or suggestions for amendment. And Ms. Sankis, you have a question or a comment?
I do. I would recommend inserting only under B, the first bullet point, after the word transcription. I think that would make it a little clearer.
So let me read it out. Interrupt is needed to protect the record. See best practice pointer number 1. The use of inaudible is for use only in a transcription. Is that where you'd like the only placed? So
in a transcription only where a live court reporter is not present to clarify the record.
Thank you. Okay, let me. Are there any other thoughts by board members on this amendment, as well as our executive officer, Ms. Finner? Yes, Ms. Finner?
I would just note that the possible language for the motion when you're finished with your review is to approve as amended.
Yes. The amendment, though, you support as a staff?
Yes.
Okay, thank you. Thank you. That's what I was trying to get to. Thank you, Board Member Sankis, for the suggested amendment. Are there any other thoughts? I did note when I read, I guess, the 4th bullet point down from A, I said, paper mask is preferred, and I was curious about that. But I did see that there's a please note at the end that suggests many different ways that you can protect yourself and be safe. And in particular, you should consider the county's current public health order as the best way to do so. So I have no problems with the way that it's written. I will now take it before the public for public comments. Let's see if anyone would like to make a suggestion in amendments.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon on your screen. Type, I would like to make a comment into the ask field and submit that to all panelists. We have a request from Mike Hensley.
Okay.
Mr. Hensley, your microphone is unmuted and you will have 2.
We've made it to the afternoon. Good afternoon. This is Mike Hensley, president of CCRA. And for clarity, I will outline our proposals followed by support of rationale for each. CCRA proposes to entirely remove item A, bullet point 7. We also propose to entirely remove item C, bullet point 6. For item A, bullet point 7, a reporter does not need to be the host of a session in order to identify all participants. Aside from using various platform capabilities, this can be done as simply as verbally inquiring prior to proceedings on the record as to who all are present for the proceedings. In fact, this process is described in item B, bullet point 3. Secondly, inclusion of this advice would be in direct contradiction to NCRA Advisory Opinion 44, from which I will quote, Conclusion, the Committee on Professional Ethics has determined that a reporter may not act as both the videographer and the verbatim reporter for the same proceeding. The paramount duty of the reporter is to provide an accurate record of the proceeding, unquote. By asking the reporter to be in charge of the video recording of the web conference, this is in direct conflict with the advisory opinion. It would force the reporter to assume duties that are typically performed by a videographer who specializes in handling such types of media. This would place undue burden of responsibility on the reporter with duties for which they are not licensed or possibly even trained for. This
30
practice
seconds.
would introduce far too many risks that would compromise integrity of the record. For item C, bullet 6, California Rule of Court 3.6700 states that all proceedings involving telephone appearances must be reported to the same extent in the same manner as if participants had appeared in person. Bullet 5 also advises no modified or partial certification pages allowed. Therefore, bullet 6 should not allow for a best of my ability clause to be used. The phrase "to the best of my ability" is used in transcription where a live court reporter is not present to clarify the record. This logic is similar to the explanation in item B, bullet 1, speaking to the use of inaudible parentheticals. Thank you.
Thank you for your comment. All right.
Seeing no additional requests, we will close the panel.
Thank you. So I'll bring it back before the board. Are there any comments from the committee with regards to some of the suggestions? And I will begin with Ms. Finner, please.
Thank you, Madam Chair. I don't believe that the language that's in the controversial bullet point under A reads that the court reporter is acting as the videographer in any way. As a host of the Zoom meeting just gives you control over the recording. And I think that was the intent of the committee, as I remember their work, was to make sure that they were in charge of the control of the video, not the videographer aspects of it.
Thank you for clarifying that. I also saw, oh, our hand went down. Board Member Sunkeys, did you want to make a comment? Maybe not.
I wondered if it would be appropriate for the task force to have further discussion before a new draft is submitted.
I see Board Member O'Neill's hand raised. Is there a comment that you'd like to make to that effect?
I was going to make the exact same suggestion that Robin just made. I think we need to go over it one more time before we get it in final form.
Okay, and I see Ms. Finner, you are not on mute, but I see your hand raised. Is there additional thing you'd like to say?
I was just going to say that it could be reviewed at the committee level and brought back.
Okay, it sounds like we have multiple individuals that are supporting that. And when you say the committee level, you mean the best practice pointers committee. So I think that's an excellent idea. I mean, we don't want any confusion. We definitely want to get this exactly right. If there are questions from people, and they look like there's something that could be improved so that there aren't any questions, absolutely, let's bring it back to the committee and get it cleared up. I see Board Member O'Neill's hand raised. And by her expression, she did not want it raised. Okay. All right. So I don't think we have to move that it goes back to committee. Do we, Ms. Finner, or can we just make that suggestion verbally?
No, there would be no motion to accept it. And so it's just direction for the committee to meet again.
Okay. So I definitely have heard a majority of the board members state that it could go back to committee for further reflection and review. And so this item will not be moved for approval at this time. We look forward to seeing the improvement of it from the committee. Thank you very much. We're now at 11.3, an update to the board on the action plan.
Thank you, Madam Chair. As we do at every meeting, we have updated the status of the items that we've completed in our action plan as part of our ongoing strategic plan. As always, we invite the board members to let us know if you think that any of the priorities should be changed and given more urgency. Thank you.
Thank you. So I'll turn it to the board members. Are there any action items that you see based upon the target date that you would like to shuffle, change? Please raise your hand. I know for myself, I was looking at the launch of strategic awareness campaign in collaboration with external stakeholders to educate consumers about the court reporting roles and CRB responsibility and services. I thought pushing that forward might be better than December 2023 target date. Ms. Finner, do you have any comments or thoughts about that kind of amendment or edit?
No, we just rearrange as we need to, but we're fully staffed right now, and I think that we can take this on for you.
Okay, thank you. Do other board members support launching a strategic awareness campaign to educate consumers about court reporting roles and CRB responsibilities sooner than this December 2023? Board Member Sunkeys?
Absolutely. It seems that this would be timely.
I
now.
agree. Thank you. Thank you for that support. Board Member O'Neill.
Yes, I agree with that. I'll be real succinct. Let's, move it forward.
Okay, excellent. All right. Well, Ms. Finner, you've heard kind of the edits we're interested in doing in our action plan timeline here. And so if you could just implement that at your stage, that would be great. And we'll follow along to see how that awareness campaign evolves and unfolds.
We've heard you and are happy to take that on for you.
Perfect. Thank you. Board Member O'Neill, I still see your hand raised. Are you wanting to comment more? Okay, and now I'll turn it to public comments to see if there are any public comments on the action plan.
This is the moderator. We have opened the Q&A panel. If you'd like to submit a request for public comment, please click on the Q&A icon on your screen, enter "I would like to make a comment" into the ask field, and submit that to all panelists. We have a request from Mike Hensley.
Okay.
Mr. Hensley, your line is open. You will have 2 minutes.
Good afternoon. This is Mike Hensley, president of CCRA. I would like to draw the board's attention to a vital item and its pending timeliness. The item to investigate real-time captioning standards and assess industry practices for consumer protection has been set with a deadline of December 2020. On behalf of the captioning community of our membership, and also in the interest to support the deaf and hard of hearing communities, I would urge the board to attend to the urgency of this matter and the importance of this matter, and to maintain the deadline as set in the proposed timeline. Thank you.
Thank you. Do we have any additional public comments?
Nope, no additional requests at this time. I will close the panel.
Thank you very much. And now I'll ask Ms. Finner, I see your hand raised. Do you have a comment?
I would just point out that these are not deadlines. These are target dates that were established early on in the process. And they are, the reason that they're here is so we have something that we can work toward. But there are other issues such as moving the platform online that took a great deal of staff time. And so it would be completely unrealistic for us to think that the investigation into something like this would be done in the next 2 weeks.
Yes, I don't have that expectation. I don't see any hands raised from the board. And I'll also say, I think the effects that we've had here in the year 2020, the different ways we've had to pivot, and we are indeed a small board, that many of those target dates that we had set early on, I think we all recognize that those are going to have to be edited. So to that end, as you see though, with the target dates, there's obviously 1, 2, 3, 4 items, 4 which we're already working on, that are coming up here shortly, and so they're definitely top of mind, and we are working to accomplish them. Are there any board comments, discussion? I don't see any hands raised, so let's move on. So the next is the election of officers. The election of board officers shall occur on an annual basis for the first regular meeting of the board after June 1st of each year. The purpose of this item is to conform to this policy. We have the election of chair and vice chair. And I'd like to just say at the start, it has been an honor to sit as chair. I definitely am very busy in my life right now, and there are many different things happening, and I think we need a really strong leader who can dedicate a lot of time to the mission. And so I would like to be taken out of contention for the chair. I'm happy to support otherwise, but I think my time is done, and I'm happy to pass on the gavel to a fresh face and a fresh voice. So I see Board Member O'Neill's hand raised. Yes.
Yeah. Okay. I have been really impressed with Robin Sunkey's involvement with the board, even for this short period of time. I know her background. I know she's been in many leadership positions, and I have no hesitation nominating her for chair of the board for the next year or more.
Excellent. So I see that. I think that's a great suggestion. So is that your motion actually? Well, let's see Board Member Nocella if she has thoughts around this as well before we go to motion.
Yeah, I first want to say, Chair Hurt, you've done an outstanding job, and you've been the chair as long as I've been on the board, and you run a meeting, and you are just truly, truly thoughtful and awesome at what you've done. So I want to say thank you for that and your leadership.
Thank you.
I agree. You know, I'm sad I'm leaving the board because I felt like this was my moment. No, I'm just kidding. But I agree with what Board Member O'Neill said. I've been very impressed by Board Member Sunkey's, and I think she'd be fantastic as a new incoming chair. So I'll toss it back to Tony if she wants to make the motion.
You could just, there we go.
Yes.
Perfect.
I would like to make the motion that for this coming term, that Robin Sunkey's, I'm not wording this really, I'm not being very articulate right now. I would like to make a motion that Robin Sunkey's be elected as chair of the Court Reporters Board.
Can I make a second? I'd love to second that. So we have a motion and a second, and now I'll take public comments.
This is the moderator. We have opened the Q&A panel for requests for public comment. If you'd like to make a comment, please click on the Q&A icon on your screen. Enter "I would like to make a comment" into the Ask field and submit that to all panelists. At this time, we have a request from Mike Hensley. Mr. Hensley, your microphone is unmuted. You will have 2.
Good afternoon. This is Mike Hensley, president of CCRA. On behalf of CCRA membership and its leadership, we would like to graciously thank Madam Chair Hurt for her steadfast and diligent efforts in overseeing the board of directors during her tenure. We appreciate your efforts and we wish you the best in your future pursuits. We also wish you peace and rest in your time in other activities. We would also enthusiastically endorse the motion as presented to nominate Robin Sunkeys as potential chair of the board. Thank you.
Thank you. Are there other public comments?
Seeing none at this time.
Okay, excellent. All right, we've got a motion and a second. If we could do roll call vote.
Thank you, Ms. Nocella.
Yes.
Ms. O'Neill,
Yes.
Ms. Sunkeys,
Yes.
Ms. Hurt.
Aye.
Thank you. Motion carries.
Excellent. I don't even think we asked Ms. Sunkeys, board member Sunkeys, if she was up for it. She didn't have her hand raised, so I think all was well. Okay, so now we're moving to the vice chair role. Are there any nominations? Well, I will move to nominate board member Tony O'Neill. I don't think I asked, but I'm going to see.
I second that motion. This is Robin.
Excellent. Okay, so we've got a nomination, and I'll move that Tony O'Neill serve as the vice chair for the upcoming term. And I don't see any other hands raised, so let's go to public comments and see if there are any public comments on this item.
This is the moderator. We have again opened the Q&A panel for public comment. If you'd like to make a public comment, please click on the Q&A icon on the screen. Type, I would like to make a comment into the ask field and submit that to all panelists.
Okay.
Seeing no requests, I'll close the panel.
Excellent. Okay, roll call vote.
Thank you, Ms. Nocella.
I believe, I'm sorry, my vote is aye, but I believe Mike Hensley had a comment. It came in late.
Oh, sorry. Okay. All right. Could we pause the, well,
You are correct, he did.
Okay, so thank you for that catch, board member Nocella. Let's pivot then, if we could, before we move with the vote, to public comment with Mike Hensley. Mr. Hensley.
Mr. Hensley, your line is open. You will have 2 minutes.
Thank you. I appreciate it. Mike Hensley, president of CCRA, and CCRA stands in support of the motion to nominate Tony O'Neill as vice chair. Thank you.
Excellent. Thank you very much. Okay, so then we'll go back to roll call vote. Ms. Bruning, if you could begin with board member Nocella.
Thank you, Ms. Nocella.
Aye.
Thank you, Ms. O'Neill.
Aye.
Thank you, Ms. Sunkeys.
Aye.
Thank you, Ms. Hurt.
Aye.
Motion carries.
Excellent. So I'll do claps. Very much excited about the leadership with the board. I think it's going to be excellent upcoming year, and looking forward to serving on the board with the leadership of Chair Sunkeys and Vice Chair O'Neill. Excellent. So if I continue on our agenda, and I think we're really coming to the end here, there is the future meetings date, agenda item 13. And per my notes, as everyone remembers, we will reach out to you via email for suggested times. I know I'm no longer the chair, but I will point out that we did not have as many meetings because we were trying to tighten our belts so we could get the TRF back up. And so I would suggest, because now we have this online platform and the costs of moving staff and all the other details are not present. So this may be an opportunity to have more meetings and shorter meetings since we have this online platform. So I'm just going to throw that out there, but that is the decision and the pleasure of our upcoming chair and vice chair. Okay, then if there are no comments on the future meeting dates, I guess I do need to put it before public comments. Are there any public comments on what I just said? Because there are no dates etched in stone yet.
This is the moderator. We have opened the Q&A panel and are displaying instructions on the screen.
Okay, I don't see any hands raised, so let's move on then. Thank you very much. So let's move on to what will be our closed session. We'll recess this general board meeting, go into closed session. We'll return from recess to state whether there's any items to disclose, and then we'll adjourn for the meeting, as I understand. Is that correct, Ms. Finner?
I think we may need to take a longer break, at least a comfort break, but possibly a lunch break.
Okay, well, that we can do. So should we take our 30-minute lunch break and then start our closed session, but go ahead and recess?
I think board staff can do it in 20 minutes. If the other DCA staff, I would reach out to the moderators and ask what their preference is as well.
Thank you. It is 12:41. We had a break earlier, but it is lunchtime. So I'm happy to support everybody who's working to make this happen. I hear staff said they can take 20 minutes, and DCA members, support team, is a 20-minute lunch.
This is the moderator. That will be sufficient.
Okay. All right. We're almost done with this. We did think we were going to be in a meeting till 3, but I don't think that's going to happen. So, but let's go ahead and support having a lunch break of 20 minutes, and then we'll return back here in 20 minutes, and then we'll do a closed session. Okay?
Please, excuse me, Madam Chair, this is Ms. Bruni. Please stay logged in. You can turn off your cameras and microphones, but we will not be actually leaving this WebEx session, so please stay logged in.
Thank you for that. Yes, everybody just make sure you mute yourself and cut video off, and we'll be back in 20 minutes after our lunch break to finish our meeting with the closed session and then adjournment. Thank you very much, everyone. Have a great lunch.